the other stakeholders who work in this environment on access to justice with the community advice centers. And I see my colleagues, my friends from the Legal Resources Center that are here, the organized legal profession, lawyers for human rights, the community advice centers. So we are saying this is how we build the ecosystem on access to justice, because we complement each other. We don't compete with each other. And as we complement each other, we find solutions. And these solutions we want to channel through the Chapter 9s to offer our hand to government and say to government that we are ready to join hands with you to advance the rights of children in the capacities we have. Now, children's rights are key to the work that we do at Pro Bono. Advocate Elizabeth Steenhuisen, who's the head of the One Child a Year project, and the acronym is OK. And it's not okay to see children in stress and in distress. So we have done with a limited capacity, over 35,000 cases in the 19 years that we've been there, and we've attended successfully to 735 cases on children's rights in the unit itself. So we have a lot to offer in terms of our capacities. Just to give you a brief synopsis of the kind of work we do here, we do wills, we do deceased estates, family law, gender-based violence-related matters, labor law, housing, refugee law. And as I said, we give hope to the poor and vulnerable. When they come to our doors, we never turn anybody away, Judge. It doesn't matter whether they made an appointment or not, because we know these are people who are poor, who cannot come a second time because they cannot afford to come a second time. So we would give them the time of day and the remedies that they require. So on that note, I'd like to just, Program Director, highlight the kind of things that we want to do with this, get out of this particular symposium. Now, just a brief background. We're saying that South Africa became a signatory to the United Nations Convention on the Rights of the Child in 1993, which was ratified on the 16th of June, 1995. And this convention was the first international treaty ratified by the newly democratic South African government. This symposium aims to reflect on South Africa's progress in meeting its international treaty obligations to protect the rights of children. Today is 11th of June, 2025, and it's 30 years since we celebrated the great moment when we signed this treaty and it was domesticated as well. And so this gives us an opportunity today to evaluate South Africa's commitment and adherence to its international treaty obligations to protect and promote children's rights. This assessment will focus on measures implemented by the state to ensure compliance with our treaty obligations. Pro Bono has strategic partners, and one of its strategic partners are the Chapter 9s, and in particular, we selected two of the Chapter 9s that basically also work among the other Chapter 9s on issues affecting the rights of the children. So it's the Commission for Gender Equality and the South African Human Rights Commission. It's the Public Protector. It's also the Commission for Religion, Language, and Cultural Communities that also do a lot of work around children's rights itself. So we've identified significant deficiencies in state services provided to children and their families over the years. And the commemoration of this convention offers a crucial moment to reflect on these issues and to hold the state accountable for its commitments locally and globally. It is essential to highlight the challenges children face if they are to benefit from the protection mechanisms of the Constitution. The purpose of this convention, colleagues, esteemed guests, is to commemorate, as I said, the 30th anniversary of South Africa's ratification to the Convention on the Rights of the Child, to reflect on the progress made and to address the ongoing challenges in protecting children's rights in our country. This event, colleagues, esteemed guests, will provide a critical opportunity to hold the state accountable for its commitments and to advocate the necessary measures to ensure that the rights of children are respected, promoted, and advanced and upheld, both under the Constitution and the Bill of Rights, as well as South Africa's commitments to the treaty that was ratified 30 years ago. So the objectives of this symposium is to, number one, evaluate progress in this regard. And here we are going to focus on, we're going to assess South Africa's adherence to the convention and the measures implemented to ensure compliance. Number two, we're going to highlight the shortcomings and identify and discuss deficiencies in state services provided to children and their families across all 9 provinces. Number three, the accountability aspect of it. We want to hold the state accountable for its commitments to children's rights within the framework of the Bill of Rights and the Constitution, as well as its treaty obligations, as discussed earlier. Number four, we want to use this symposium as a platform to raise awareness of the challenges children face in benefiting from the protection mechanisms established by the convention. This symposium is a hybrid symposium. It's in person here, and it's also attended on the virtual platforms as well, as I mentioned earlier. Key speakers will outline in the course of this event strategic measures linked to the convention, focusing on civil, political, economic, social, health, and cultural rights of children. This event will serve as a platform to discuss the progress made and the challenges that remain in ensuring rights of children are upheld. We also, in this regard, have provincial events, concurrent activities that will be organized to engage communities across South Africa. Stakeholders will provide services to local communities, ensuring widespread awareness and participation. These activities will include workshops, provide legal aid clinics, and community outreach programs aimed at educating and empowering children and their families. And our stakeholders, as part of the Access to Justice ecosystem, we have invited stakeholders through the Strategic Collaboration Partnership for Impact, primarily because we know we can't do it alone. We have to join hands through a strategic collaboration partnership to get maximum benefit to the people who need it most, the vulnerable and the poor, primarily and in particular the children who are always bearing the brunt of the challenges that our society is facing now. And in this regard, we've called on all the Chapter 9s. And as you know, the Commission for Gender Equality is an independent statutory body that was established under Section 187 of the Constitution in 1996 with a particular mandate to promote respect for gender equality and protect and develop and achieve gender equality. This is very important in relation to the abuses that our girl children are going through in society today. And this is a big concern which will come out in the discussions that we're listening. We're looking at government agencies to help us as well, and various government departments and agencies responsible for child welfare and protection. And in this regard, we've invited a high delegate from the Gauteng Gauteng Social Development Services, Mrs. Daphne Naidu. Thank you for making your time available for this important event. The non-government organizations, as I mentioned, we work very closely with the LRC, the LHR, and many other organizations and community advice centers so that we can ring-fence the problem statement and we can advance the rights of children in a safe space and in a tangible manner. We're also looking at community leaders, the local leaders who play a crucial role in advancing and protecting children's rights. And of course, this can never be done. This is where pro bono has the competitive edge. It works through what we call a clearinghouse model. It's a unique model. What it does is, we know we deal with vulnerable and poor people who can't afford legal services. Legal services are prohibitively very, very expensive. So through the clearinghouse model, with our staff of 30, we then reach out to the organized legal profession. And we have 535 legal practitioners who volunteer 40 hours of pro bono services. And in that way, we get the best legal help for the poorest of the poor. And it's a win-win situation. Just to give you an example, in 2024, through this ecosystem, we did 5,037 cases with 30 people and 535 lawyers that helped us to do that. And through this ecosystem, we resolved 70% of those cases in-house itself, which is phenomenal. And if you look at our annual report of 2024, you will see that we had done over 10,000 hours of work, 10,000 hours of work, translating into over 30 million rand. We are a donor-driven organization that has an operating budget of 12 million rand. So this is the commitment from pro bono, and we are challenging others to help us to reach our targets through this commitment. In conclusion, I'd like to say the symposium promises to be a significant event in reflecting on and advancing children's rights in South Africa. By bringing together key stakeholders, this event aims to evaluate progress, highlight shortcomings, and hold the state accountable to its commitments. The focus on both national and provincial activities ensures that the message of children's rights and the protection in South Africa, and their protection in South Africa, reaches all corners of our country. The commemoration serves as a reminder of the importance of upholding the rights of the most vulnerable members of our society, and that is our children. In conclusion, I'd like to say, Program Director, we need to understand that South Africa's international commitments are aligned and should be aligned with South Africa's promises to the National Development Plan Vision 2030. It has to align with the United Nations Sustainable Development Goals Vision 2030. It has to align with the African Union Agenda 2063 as well. And we are in 2025, which is almost over, the way time is flying. We've got 5 years, and we're asking our strategic partners, the Chapter 9s, to help us to hold government accountable, to tell us as a society in the next 5 years to reach the targets of Vision 2030, what is it, what programs they are going to put in place. And we are basically challenging the Minister in the Office of the Presidency advancing the rights of women and children and vulnerable people. What are they doing about it? We are saying to the Department of Justice that we are willing to take hands with the community advice centers to reach out to the poor and vulnerable. And we are saying as we build this ecosystem, we can make it all happen together. I'd like to acknowledge Advocate Shireen Sayed, who's just come in now as well, from the Department of Justice and Constitutional Development. And welcome, Shireen. And we also know that there are a few people that may have to leave early. We acknowledge your time for coming here, and we thank you for your time. And I wish everybody a successful conference today, and we're going to go out with tangible resolutions for which we can then take this process forward. It is said that 30 years ago, we were all upbeat about signing this international convention. But 30 years later, it was all silent. And so I said to Advocate Steenhuisen, who works with me, it can't go unnoticed. It was a very important milestone, and the children are our future. So we need to protect, promote, and advance their rights. And so thank you to Pro Bono, the staff of Pro Bono, and thank you to all the stakeholders who made it possible for us to be here today. And thank you to all of you for coming. Lastly, I'd like to say that we're showing a movie tonight, which we're inviting everybody to. It's at the Killarney Mall at 6 o'clock at Avalon Cinemas. If you are able to attend, please do come. It's called The Greytown Girl, which is about the challenges a young girl faced in her life and made it in life. It's one of the nominations for the Cannes Festival Award in France as we talk now. So you are most welcome. It's free of charge, and we look forward to seeing you there as well. Thank you, Program Director, and thank you, everybody.
Thank you for such a succinct and profound background on the work of Pro Bono and why we're here. And I'm grateful you have eliminated that question that people like myself, normally in gathering such as this, we ask, what's so different from others? So you've answered that very well, and I'm grateful for that. I've said the resumes of the colleagues seated here next to me are very short. I'll read for you so that you understand what I saw when I read them. I was told not to go through the whole resumes, but I realized these ones are very short, all of them. They've given us something short. I once became a program director somewhere where someone gave the whole CV, and I said, it's not a resume. They said it is. And when they gave me the CV, it was 10 pages long. So, but here it's something different today. Our first guest who will be on as per our program, will speak on the issues, the importance of the UN Convention on the Rights of the Child. It's Ms. Abigail Noko. Ms. Noko is the regional representative of the Regional Office of the High Commissioner for Human Rights in Southern Africa. She has worked at the Office of High Commissioner for Human Rights for over 20 years in various capacities. Prior to her current posting, she oversaw the office work from headquarters in East and Southern Africa and the African Union. And she also undertook a special assignment in Sierra Leone, Nigeria. She previously worked as a special assistant to the Assistant Secretary General for Human Rights, the advisor on HIV, and worked on external relations and donor relations. In her current capacity, she's responsible for overseeing the work of the regional office, which cover 14 countries. Amongst those is Angola, Botswana, Comoros, Lesotho, Madagascar, Malawi, Mauritius, Mozambique, Namibia, Seychelles, South Africa, Swaziland, Zambia, and Zimbabwe. This includes providing technical assistance in advisory services in human rights to states, United Nations agencies, sub-regional organizations, national human rights institutions, and civil society organizations. Ladies and gentlemen, I give it to you, Ms. Abigail Noko, to come and share with us this aspect. However, before she comes through, this event is being streamed live on the platform for the Commission for Gender Equality on Facebook, which is Commission for Gender Equality, and also on YouTube, Commission for Gender Equality. I also ask those that are listening from home, switch off your cell phone and put it on silent, because you're not going to miss anything so profound as this today, because I told you we have got cream of the speakers today. So when you're at home, and as a good neighbors, and we're glad as a commission, we are welcomed. Everyone else, we are as good neighbors. I'm the program director. I did not want to say that much where I'm coming from, because we're just good neighbors like that with Pro Bono. Ms. Abigail Nobo.
Thank you so much, Program Director. I wasn't expecting that extensive introduction, but I'm really honored to be here and to share this podium today with other eloquent speakers. And we need to thank you, Shafia Mirmir, for always finding ways to collaborate and most importantly in the convening today. I would also like to begin by, recognizing Advocate Shireen Seed, the DDG at the Department of Justice and Constitutional Development, and a very important partner as well for the Office of the High Commissioner for Human Rights. Judge Dacio for being here from the High Court, and Justice Linda Retief, from the Gauteng Division of the High Court, Advocate Sipanye Mokhale, Chairperson of the Commission on the Gender Equality. Who else? Daphne Naidu. It's great to be able to share the podium with you as well from the Gauteng Provincial Program Head of Child Care Protection Services at the Department of Social Development. But more importantly, I should say, dear friends, dear colleagues, and vitally important, dear children. Just a week ago, South Africa observed Child Protection Week, a week dedicated to raising awareness and reaffirming our commitment to the safety and well-being of every child. The theme this year was working together to end violence against children. As we observe this important week, and in preparing for this address, I found myself thinking, once again, about the horrific incidents of violence against children that have occurred in the past weeks. I choose not to name them by name in the best interest of protecting the child. We know of a 6-year-old girl from the Western Cape who was trafficked. A baby girl, 8 days old, from Gauteng, who was raped and then murdered. But there are many, many more. The South African Police Service recently reported 60 cases of rape at schools between January and March alone, with 26,852 cases of child abuse and neglect during the same period. The Teddy Foundation reported last year that out of more than 5,000 cases it dealt with between 2019 and 2024, only 4% led to convictions. These are simply incidents that must keep us all awake at night. They are a sign of a deeply wounded society. They are also a sign of how much more needs to be done to revitalize investment in the rights of all children. For this reason, this symposium is particularly timely, and I wish to extend appreciation to the Commission on the Gender Equality and probono.org for convening this discussion to reflect on South Africa's progress, but also to galvanize action and call upon our collective duty to protect and promote children's rights as South Africa commemorates 30 years of adherence to the United Nations Convention on the Rights of the Child. The Convention on the Rights of the Child was adopted by the United Nations General Assembly in 1989, and it entered into force in 1990. It was the first international human rights treaty that South Africa ratified 30 years ago, just after its first democratic elections, and it is no coincidence that it chose June 16 to do so. It was a profound commitment to upholding and advancing the rights of every child at a time when 180 member states or countries around the world had already ratified it. Today, It is the most widely ratified United Nations Human Rights Treaty in the world, with 196 state parties, reaffirming that children's rights are universal, indivisible, and fundamental to the well-being and progress of all societies. In the most simplistic terms, the Convention recognizes that children have human rights, and they should be empowered to claim them. Whether in its recognition of children as active rights holders with ability to meaningfully participate in decisions that affect them, children with the right to express their views and have them taken seriously, or children who actively shape responses to key global issues, including climate change, digital governance, mental health. The Convention on the Rights of the Child has simply been transformative. This transformation has taken root in South Africa through subsequent ratifications of the optional protocol to the Convention on the Involvement of Children in Armed Conflict in 2009, the optional protocol to Convention on the Sale of Children, Child Prostitution, and Child Pornography in 2003, and the African Charter on the Rights and the Welfare of the Child in 2000, further solidifying its human rights obligations towards children in South Africa. The Convention's principles and provisions remain critical as South Africa and the rest of the world confront evolving human rights and development challenges. Whether in times of peace or conflict, international human rights law and humanitarian law are broken with impunity, and children are often the most vulnerable victims. The Convention on the Rights of the Child is an important instrument to change course and advancing South Africa's progress on sustainable development goals including in relation to ending poverty, SDG 1, ensuring quality education, SDG 4, or reducing violence, SDG 16. All are essential for breaking intergenerational cycles of inequality and exclusion. The international obligations under the Convention are not symbolic. They offer a yardstick of progress in sustainable development. This yardstick begins with translating the Convention into legal, policy, and regulatory frameworks within which children's rights are recognized in South Africa. An important starting point, therefore, is evidently the Constitution. Section 28 guarantees every child the right to basic nutrition, shelter, health care, and protection from abuse. South Africa has also made progress in relation to key legal and institutional frameworks through the enactment of the Children's Act in 2005, the Child Justice Amendment Act in 2019, the National Child Care and Protection Policy in 2019, the Customary Initiation Act in 2021, the Criminal Law, Sexual Offenses and Related Matters Amendment Act in 2007, the Children's Amendment Act 17 in 2022, and the establishment of the Office on the Rights of Children that plays a crucial role in coordinating and advancing children's rights. South Africa has maintained regular constructive engagement with the Committee on the Rights of the Child, responsible for monitoring implementation of the Convention by state parties. Following these engagements, the committee identified progress made in the implementation of the Convention and issued recommendations to South Africa in 2000, in 2016, and in 2024, offering valuable guidance to strengthen the realization of children's civil, political, economic, and social and cultural rights. The committee's most recent concluding observations, issued last year, indicates progress in the application of the rights and principles stipulated in the Convention in its national jurisprudence. It also noted progress in the overall reduction of infant and child mortality and vertical transmission of HIV, an increase in school enrollment, and improvement in some critical health indicators, such as infant and under 5 mortality, through initiatives like the expanded program on immunization and child support grants. South Africa has also been leading the charge in adjudicating on children's rights. The S versus M case was the first court judgment in the world to address the issue of children of incarcerated parents from a children's rights perspective. In that case, the Constitutional Court held that when sentencing a primary caregiver, courts must give serious consideration to the best interest of the child. The court referred to both the Convention on the Rights of the Child and Article 30 of the African Charter on the Rights and the Welfare of the Child. This judgment later influenced the development of soft law at the international level, including the inclusion of language on children of incarcerated parents in United Nations General Assembly resolutions 2009 and 2012, and the adoption of Rule 64 of the Bangkok Rules in 2011, which calls for non-custodial sentencing when the best interests of the child are at stake. The African Committee of Experts on the Rights and Welfare of the Child later issued a general comment explicitly drawing on this case and further broadening its application. This case illustrates the interconnected nature of the world we live in and the magical marriage of the broader human rights ecosystem, where international and regional norms and standards can influence domestic law, and where domestic law can influence international and regional standards. Nevertheless, as South Africa commemorates 30 years of its adherence to the Convention on the Child, much work remains to safeguard and advance children's rights. This includes working towards the implementation of the medium-term strategic framework for 2024 to 2029, which puts children as a national priority, and ensuring that responsibilities for the implementation of the National Action Plan for Children are clearly defined and supported by sufficient human, technical, and financial resources. As my colleague, the UN country representative of UNICEF has aptly put it, we urgently need comprehensive, sustained, and integrated efforts to protect children's well-being during periods of economic hardship. South Africa should ensure children's best interests are a primary consideration in all legislative, administrative, and judicial proceedings and decisions, as well as in policies, programs, projects, and resource allocation, including in the environmental, economic, and administrative sectors. This must start with the important issue of birth registration. Apartheid denied the peoples of South Africa their fundamental rights and dignity and worth of the human person. One way it did this was through documentation and the denial of documentation. 30 years on, we all must ensure that this is not repeated by achieving universal birth registration. And one must recognize that South Africa has made progress in the area at a reported rate of 91%. But the last 9% are those furthest behind, and those we must strive to reach with urgency and determination. This issue of documentation is not merely an administrative concern. It is a fundamental enabler of human rights, a key to accessing education, healthcare, social protection, and justice, a name, an identity, being seen administratively as human. Without proper documentation, many people, particularly the most vulnerable, are denied their basic rights and opportunities to contribute and benefit from society. This reality disproportionately affects children and marginalized communities, deepening inequalities. Another area to address is in strengthening the prohibition of corporal punishment in all settings, particularly in schools and institutions. This includes by promptly investigating and sanctioning perpetrators and by providing children with safe and confidential complaints mechanisms that do not expose them to further victimization. Violence against children must also be urgently addressed by promoting family or safe family environments and alternative care. Socioeconomic conditions are also pertinent, such as improving health and healthcare services to children, standard of living, education, leisure, and cultural activities, and protecting the rights of asylum seekers, refugees, and migrant children, as well as children with disabilities. These are just a few examples, and I'm sure my colleagues will be speaking to many more. But the next important bold step for South Africa, as it reaffirms its commitment to the CRC, is to ratify the optional protocol to the Convention on Individual Complaints Procedure. This is a supplementary treaty that builds upon the core provisions of the CRC, offering additional protection and mechanisms for ensuring children's rights. It allows for complaints to be directly submitted to the Committee on the Rights of the Child, which is a vital avenue for seeking redress and ensuring that children's rights are upheld in the absence of effective national remedies. However, I must emphasize that these efforts will be for naught if we cannot stop the senseless violence against children that we continue to witness in this country, on this continent, and the world over. There are still far too many horrific incidents of abuse and human rights violations against children, and this is a sign of our collective failure. No child is safe until all children are safe. Children's rights are not just a legal obligation. They are a moral imperative. They are the foundation of our shared future. All children deserve the best chance in life to grow with dignity, to live in safety, and to be given the opportunity to thrive. This must be the promise to our children, now and for generations to come. It is what the Convention on the Rights of the Child stands for. Thank you.
Thank you so very much. I was glancing and looking at people writing, taking notes, and I said, wow, this is the place that I want to be. And when I grow up, I want to be like you and speak it so eloquently on issues. And I remember one mistake once someone tried to summarize people's speeches, and I shall not do it because people can move out of this room if I try to summarize. We are here for what the purpose of this gathering, and then we're going to discuss. We're not going to discuss now, and I have got presents for you sitting here, so don't even you leave, because between 1 o'clock and 1:30, you are going to be mesmerized by a choir, and you have never heard this choir speaking, and I'm the conductor of the choir. You will be shocked. At this point in time, can we call Lufuno or Margaret, one of the two, or Daphne, to come? Lufuno is close by. Miss Abigail, can you come and get something from the colleagues from Pro Bono? Thank you very much. I do not know whether we still have others for the other remaining three, but I think we might have, because as I told you, colleagues, we're going to the next speaker. We are going to have a discussion after all they've spoken, all of them. Please write down your questions and every input that you want to put, even online, put it on the chat group. We are going to get all of those things answered to you. We are not going to leave anyone behind, because this is an important topic altogether. I'm going to call someone who went to my former alma mater, University of Pretoria, Honorable Madam Linda Retief, Senior Counsel, because we have to be very careful. There's counsel and senior counsel. Was elevated to the bench of High Court in June 2023. Prior to a judicial appointment, she practiced as a legal practitioner for 30 years. She has got all the qualifications that you know in the legal fraternity. During her time as a practicing attorney, she was appointed instructor for the Law Society of South Africa, preparing candidate attorneys in practice of high court litigation and personal injury claims. She did the training for a decade, a division for the Law Society of South Africa led, and also appointed her during this time to train admitted practicing attorneys on various topics ranging from small business practice, black economic employment, and personal injury claim. In 2006, she closed her private practice, so that she could embark on serving a pupillage at Pretoria Society of Advocates. She was duly admitted as an advocate in 2007. She was recommended for senior status by members of the Pretoria Bar in 2022, the state president conferring such a letter patent as Senior Counsel of South Africa sometime thereafter. During her 15 years as a practicing advocate, she did extremely very well. Now, as a judge, she's seated at the Palace of Justice in Pretoria. She's nominated Hague Network Judge, assisting with realization and advancement of children's rights. I give unto you, colleagues, Madam Honorable Linda Retief, Senior Counsel.
Thank you, Mr. Beloy. I must say, from the short biography that was given, one thing that was duly highlighted is that I did a great deal of teaching, demonstrating in the 30 years of practicing in the legal fraternity before now sitting on the bench. But before I get into that, let me first of all say a very good morning to absolutely each and every one of the delegates before me. Of course, this includes those delegates that are live streaming wherever you might be. And Advocate Norco, if I could just say, I have never experienced such a warm welcome from any colleague at any symposium before. And for that, I just want to thank you. Yes, absolutely. I have accepted that all protocols are observed, so I will get right to it. And before I kick off, may I just say an absolute thank you to Advocate Steenhuisen and her team. And it's now not the obvious thanks. It would be that you selected my title. In other words, I was given a topic on what I was to speak about, something that I never gave them. And the topic is, as you would see, it's the role of the court in the advancement and the protection of rights of children. Now, at first blush, when I first read the topic, I thought, well, that's a fairly obvious topic, and it could be a little bit dead on paper, because that's the one thing about paper. It is cold. But having considered it very seriously, I realized that it is absolutely a fabulous topic. And that's the reason why I wanted to thank you, Advocate Steenhuisen and team. And why should it be fabulous? Well, it's fabulous for a number of reasons, but the one that does stand out, it is the first time ever that perhaps in a symposium like this, an opportunity is given to consider how life is blown into substantive law by courts. In other words, it's all very well understanding the conventions, it's all very well understanding the Children's Act, but in effect, you want to know what is that in real terms? And that is, in essence, the role of courts, whether it be a children's court or where I sit as in the High Court. So standing back and looking at it, I thought, well, if we're looking at the advancement and the protection of rights, I think of one thing, and there's only one word that all encompasses the role of a court. Being a legal scholar myself, a word that jumped into my brain was a Latin word. It's called testudo. Now, you are certainly forgiven for not knowing what testudo might be. And you will notice that I walked up with my computer. Perhaps you were hoping that there would be a PowerPoint presentation and that the word testudo might appear on the screen. I have comfort as I turn back to see the ladies behind me and notice that none of them have a computer either. So there is no PowerPoint presentation, and that's what I'm going to tell you. I always have the luxury of telling people in the audience it's because I'm not a very conventional woman. But that's not true. The reality simply is that in the 30 years of practice, I was always the PowerPoint presentation in court. And from time to time, I get a little lucky as a judge, and I too become the PowerPoint. So I want you to rather listen to my voice. An important word which I'm going to play on a little bit later, and that actually, Advocate Norco, you mentioned before about the voice of a child, and that will follow through the theme of the symposium, I think, and the theme of my topic. So let's have a look at the word testudo. Well, if we're dealing with the protection and the advancement of rights, we have to accept that we want a physical action, a manifestation of advancement and protection. If we physically do it, or I demonstrate it to how I see courts work, it is the advancement, which is a pushing action, not so, of applying substantive and the rule of law, whilst at the same time a circle movement by court where we try and protect the child. So it's an advancement and a protection. An advancement and a protection. And the reason why I say it over and over is that that's not only the role of court, testudo, but it is the role of every legal practitioner and those of you that practice in children's advocacy and law. Now, that forward movement of advancing particular ideals and substantive law and the protection of the child at the same time actually creates what I call a protective shield, a mechanism to get to an end result. In other words, the relief that the child might need that comes before a court. If some of you did Roman law, you would have learned that when the Roman legions in war advanced together and forward towards their enemy, they would form a shelter barricade with their shields, not so. They would protect themselves and they would advance forward. That is a testudo. Almost sounds like a Spanish dance, but it's not. So To start off with, I want you to see the role of the court in the advancement and the protection of rights of children as a testudo, and something which you should replicate whenever you bring some kind of action or application before a judge in court. We've all heard that children are our vulnerable citizens. But for a moment, let's see who we are really talking about. It also seems pretty obvious, but once again, words are cold and paper can be silent. So we know that in terms of the Children's Act, the children are those persons, legal subjects, and I use the term legal subjects very loosely, and you'll understand why in a minute, who from infant until just before 18 years old. In other words, we're talking about a person who has been living for just under 2 decades. Much happens in the life of a person from infancy to 17 years old until 18 when majority is attained. What we do find in courts and what we do realize as judges is that life spent and things that have happened normally happen within a family unit. A family unit, we see, can also mean a fragmented parts of a unit. In other words, it could be by death or divorce or by anything else, that a family unit is not what you might conjure up now, but the family units that are brought to us are fragmented into other working units. So in other words, within that framework of a family unit and a number of different units, the court sometimes is faced with a situation when amongst all of this, they're trying to discern the best interest of a child in that entire chaos. And I say chaos because remember, the courts are the last port of call. When you can't deal with these things on your own and you give that problem to a third party who's not within that family unit to come to some other resolution for you. In terms of mediation, I'll deal with that a little bit later. So the most important thing for the court in these kinds of instances is within the fragmented family unit as it's presented, is in all of this to try and hear the voice of a child. Why? Well, let's labor for a minute. Statutorily, in terms of the Children's Act, we must hear the voice of a child. But in terms of giving effect to a children's right when you advance it, it's incumbent upon the judge to actually find the voice of the child, failing which, how do you ascertain or discern what is in the best interest of a child? Because normally what we find in court is that the papers which are before us, which are cold, advance the narrative of the person who has given us the evidence, and within that the voice may dissipate. The beauty about being a major, this is the reverse side of it really, is that your voice is rather clear. Sometimes judges are lucky enough and they sit in a full bench in applications are brought for the admittance of young legal practitioners to practice either as attorneys or as advocates. And sometimes I'm privileged enough to say a few words to those after they have been duly admitted. It seems as though I'm digressing, but I'm not. Whilst I congratulate them, the one thing that I remind them of is the following. And this is what we call a bib, a bevy, whatever you like, but you must have seen it on legal practitioners who appear before judges or this is put around your neck. I then remind each and every single one of them that this is a token of their voice They now have their voice as legal practitioners to assist others in times of difficulty. That children don't have. So, children have the voice of their guardians. But we know as a fact that the High Court in particular is the upper guardian of all minor children. So at times, that voice must come through the courts as the upper guardian. Now, once again, have you ever thought about what it is to be the upper guardian? It means that a high court or a judge sitting in the seat of the court sometimes is the upper guardian of each and every minor child which resides in the Republic of South Africa. In other words, I'm not saying only documented children or children whose parents are entitled to reside within the Republic of South Africa. All children. How weighty is that for a judge? It may also mean, and translate into real terms, is that if I stand here in time to come, I might have to decide as an upper guardian of one of your minor children. So considering that a court is the upper guardian of all children, it's the first port of call when the mouth of the children's natural guardian in terms of guardianship is either silenced or is not acting in the best interest of that child. You would then seek an upper guardian. But as if the weight of the High Court is not beladened by being the upper guardian of every single one of your children, it too, in terms of the Children's Act, is given the duty to discern the best interest of a child that has not yet even been conceived. Now, how inconceivable might that be? So we know that in Chapter 19 of the Act, which deals with the surrogate motherhood agreement, we know that the best interest right principle that is provided to a court is also to discern whether or not the surrogate motherhood agreement should be confirmed only if it is in the best interest of a child that hasn't even been conceived. Artificial fertilization has not even been given credence. Quite a weighty task. So in other words, it's a narratuscus function and not a fiction for those of you who are legal practitioners. So it's quite a weight. So sitting as a judge, I often thought is, well, what is a voice then? What is it that I'm to hear of those that are not conceived and those who are conceived? Well, let's look at what is simple. We always start with what is simple, and then we complicate our world so that we understand it. If we look at the obvious, if we look at a dictionary meaning, because that's what legal practitioners do. You are in the art and surgeons of words. That is what you are. The voice in terms of the dictionary is just simply a sound. A sound could be a cry, a muffle, a sentence, an expressed desire, or a need of any child from infancy until they attain majority at 18 years old. Another obvious voice, which the court looks at and we discern with, which is obvious, is an expressed opinion. So a voice could also be an opinion. But those that are hidden, which the court must identify, and I'll explain to you in a minute how we do so that it becomes real to you, is first of all, as I've explained, that of those who are not conceived, and then fourthly, those who do have a voice or can make a sound, but due to trauma or infancy are unable to make a sound. So a voice, unlike the dictionary definition, is widened to include the soundless, Does that make any sense at all? Because that's really why you're here. So how does a court discern that voice? In other words, the obvious voice and those voices which are soundless. In my experience, the first port of call would be the papers before that are brought before us and the relief sought and the nature in which it is brought. In other words, is it an urgent matter for a child, or can it follow the normal course in court? The papers themselves will reveal whether or not, in the entire dispute fracas, whether the voice of the child should be highlighted to assist the relief. If that is so, a number of options are available. Let's start with the statutory obligation, and that is the access of a child to court in terms of the Children's Act. So the Children's Act says that a child has an access to court in that it can participate in the proceedings that are brought before court. But as we know, that's not always possible. Age, majority, and possibility is not the only criteria. Another criteria, which is the testudo of the court, is that it may not be in the best interest of a child for a child to actually participate by giving its own voice all by itself. In other words, if a child's asked to give an opinion of what it wants and express a view and participate, the most important manner is how does it participate within the proceedings? Does it give evidence of its own? If it does that mean that it attracts cross-examination? Is that in the interest of that particular child at that time? And who knows, it may be, but it may not be. So even though the Act says that a child can participate, it doesn't necessarily mean that it has to use its own voice by giving evidence. There are other means. A judge is highly and acutely aware of what he or she must do in that circumstance. And what is open and what we do advocate is the appointment of a curator ad litem for the child. Now, a curator ad litem in real terms really just stands and steps in the shoes of a litigant who is unable to do so by capacity or age. In other words, to give instructions to a legal practitioner. But what the court here does, and this is the role of the testudo, the advancement and the protection, is expanding the common law understanding of a curator ad litem by providing them with particular instructions to say that not only do they step into the shoes of the child, but to try and help and discern what the voice of that child is saying, and to report back to us, in other words, to author a physical written report. From that report, the court gets a jolly good idea of what the child's situation is, what its views are, and the court can then discern whether or not those views, what weight should be placed on those views. Because remember, at the end of the day, a minor's views is not ultimately what the court will do. The report itself does not become expert evidence, and this is an important part of the voice of the child. It is a factor and a consideration which the court will take into account when making a specific determination on an exercise of discretion of what is in the best interest of that child at that stage. The voice then can also be heard by way of expert opinion. This is something different. In other words, not only does the court want to hear the voice, in other words, what does the child want? How does it view it? What are its lenses to the problem of the dispute? But the child needs assistance. Psychological or social worker, it needs assistance to either extrapolate that view interpret that view for the court, and provide some or other care thereafter. That is something different. That voice is the obvious voice which I mentioned, which is opinion that comes to the court. That a court can either accept or reject, depending on the facts used and the opinion proffered. So in that way, you'll see that the court then not is protecting and advancing by hearing a voice in many different ways than what you think it should be. The court also works beyond, shall we say, the testudo, beyond the realms of the Republic of South Africa. And that you got a very good introduction of by Advocate Norco this morning. But all of you know that. That's why you're here. In other words, we know that our country has concluded a treaty. A treaty is simply an agreement of understanding with another country all over the world. A country who tries to say, we recognize that each country has a different legal system. There's different rights and there's different obligations. But surely, as a collective, we can build bridges between our countries where we can try and speak with one voice. And the one voice that we hear is not only that of the girl child crying in the distance, but it is of every child. And that is why these treaties are signed. So they sign so that there's some uniformity, no matter where the child should find itself, or no matter where the guardian should find itself at that particular time. So that is what the treaties are about. So in respect of the treaties, the role in the protection and the advancements of rights, the courts and the high courts being the upper guardian select what they call network Hague judges. So over and above all the matters that we have relating to the third arm of governing of a democratic society, some of us also have to deal with network Hague issues. This means that we get to know and can, at the, shall we say, a telephone call away, know who are the network judges in all the countries, the signatory countries all over the world. The beauty about that is that if any order should be given in the Republic of South Africa, whether it's dealing with trafficking, abduction, matters not, that we can try and obtain a mirror image abroad which has effect, because that's really what you want. You want to blow life into the substantive law, but you want to be able to action it in the form of an order of court. And that's what the role of the High Court does with regards to Hague matters. So be rest assured, the High Court is well up to speed. And for those of you who are doing your checks and balances, whether you be the executive or not, need to understand that the High Court has taken this very seriously, and we communicate all over the world, all of the time, 24 hours a day. That is how serious we take the testudo. There's something that I did forget, and I wanted to go back to it, so I'm just going to put my head down because I'm almost done, Mr. Beloy. And this is what happens when one gets a little bit older. I might come back to it. Let's say it might reveal itself in due course. Towards the end of my talk, I want to talk about something where the court also realizes that perhaps its role it must play is spreading the word that sometimes, in certain circumstances, the court adversarial system may not be in the best interest of all children. And that is the highlighting of mediation. And by doing that, it amended its uniform rules by stating that if matters come before court, there must be some kind of interaction between parties relating on whatever causa it may be, but now we're talking about children in the symposium, that you've at least tried or tested the art of mediation. before you then come to the doors of court. Like most things, Rule 41A in our division, which is the Pretoria North Division, has rather been fobbed. In other words, people just use it as lip service, and they're not really giving much attention to it. They believe that the adversarial environment of a court is the way to go. But in family court, that may not be the way to go. Our particular division has taken a stance with a court directive, which starts in our new term, which starts in July, that all matters, including family matters, of course, you must first at least show that you have attempted mediation. So by doing that, we're not forcing people to mediate, because you can't force people to mediate, but we are spreading the word by making it a directive prescript. Before you unlock a door of court, consider that there might be another way that you can deal with it. If there is, embrace that way. So that role the court has taken rather seriously. In conclusion, it's vital to remember that a right, and that includes a right of a child, is not sustainable unless there's not a reciprocal obligation. I'll say that again. A right is not sustainable unless there is a reciprocal obligation, because we're dealing with balance. So for every right a child has, no matter what age, they also have an obligation. And symposiums like this don't ever try and teach, demonstrate, show, and encourage minor children that in terms of the Children's Act, they have an obligation. Dependent on their age, the Act states that they have a responsibility to their family, to community, and to the state. So in other words, in this way, the balancing of the right and the obligation comes into perfect unison. So the testudo of advancing and protecting takes into account that very fact that children too have responsibilities in society. And before I end off, I want to say to you that the lens that one has as a judge changes substantially than when I was practicing for 3 decades. Because now I am the protector of a constitution. I protect it from the executive, and I protect it from legislation. Whilst I was adjusting my lenses, I realized that in children's matters, there's time for a change. In other words, we realize that in traditional societies, traditional surrogacy was the norm, but in modern society, it became a high, hot topic. Change the lens. We even know biblically that children were sent forth to other people in a basket down a river Nile. Now I remember the point I wanted to make. And that goes straight to the point that you're here, my sister, and that simply is, and now this is what I will end with, is that we sit in a country where fathers procreate children and then leave the room. They desert their responsibilities and rights of all minor children and move on to greener pastures. There is a definition in the Children's Act called abandonment, which clearly and squarely may very well be what is done. Yet we only find in gender equality and balance that it is only a female who is found to be criminally charged for offense for abandonment. And I'll leave you with that. Thank you so much for your time.
Thank you so very much, Judge. I saw my learned colleagues. Learned colleagues, I'm referring to lawyers, nodding their heads around here. From the back there, and I couldn't pronounce the word in Latin. While sitting, I tried to Google it also. You see, and I need to apologize to Ms. Noku. I just learned through Judge that you are advocate. Normally, I call people by their own title because you worked for it. I apologize. I was not aware. Judge, I wonder if you have considered writing a book so that I can become a judge also. And then you record it in audio. Because the way I was listening, I said, wow, I can pass an exam after she has spoken. Thank you very much, Judge. We have got Lufuno. I was called by Margaret to say that after such powerful talk and River Nile, we have got something for you. Thank you. Thank you very much. Colleagues sitting in here, please put on your WhatsApps, friends, circle, groups to say this breathtaking symposium is being streamed live on Commission for Gender Equality on Facebook, on YouTube, Commission for Gender Equality. Those that have missed out in the first two segments, I shall make sure that I make it available unto them, because we cannot dare to miss anything from the first speaker, the second speaker, and wait for the next two speakers. You don't have to move an inch. I'm reading a bio now for the third speaker. It's one of the shortest I've ever read. Ms. Daphne Naidu is currently the Provincial Program Head for the Adoption and Child, Youth and Care Centers services in the Gauteng Department of Social Development. She currently holds a bachelor's degree in social work, master's degree in clinical social work, and several other qualifications. I think colleagues, we need all to go back to school. There's no one with just a degree. They've got masters, everything up. She has got more than 25 years of work experience heading various services such as Child Protection Unit, Probation and Crime Prevention, Substance Abuse, Gender-Based Violence, Monitoring and Evaluation. Ms. Naidu's passion lies in consolidating and providing training and capacity building on various legislation and policies to stakeholders in different sectors to address various social ills. These stakeholders include social services, professional, university students, educators, magistrates, health professionals, police officials, civil society, organization, community leaders, and members. All of them, they've got one denominator. They do care about society at large. I give it to you, Ms. Naidu. Thank you.
Thank you, Chair. Judge, apologies, I do have a presentation. and the only reason I have got this presentation up is because, one, I have the flu, so I may not be that clear. And secondly, I don't know, you could all see that I'm Indian, and I have a tendency of speaking too fast, and I don't know if it's an Indian thing or not. But yeah, so that you could just maybe watch the board if you still need to understand what I've said. Colleagues, yeah, I think, when they said we need to hold the state accountable, I was sitting there like, oh my goodness, here goes the state. Because Ms. Naidu is representing one of the lead departments when it comes to the rights of children. But having said that, you take up certain roles, especially if you're belonging to government, and you need to step up. And you also need to be accountable. So I'm going to give you Gauteng's perspective on the rights of children. Look, the guest speakers have already spoken about the convention itself, so I'm not going to go into the nitty-gritties. But just to say to you that, obviously, when you set out children's rights, it's how government should work together to make them available to all children, so that we can ensure collectively, and not just government department, but also partners with yourself. So the good news is that we are not in competition with each other. We're actually supposed to be complementing each other when it comes to our services. So maybe that will be the starting point. with regards to us as partners. Look, when you look at basic fundamental rights, and we all know this, and I want to concentrate here because you will see this is critical when I go on with my presentation. You know, life, survival, and development. When we come to protection from violence, abuse, and neglect, and education that enables children to fulfill their potential, to be raised by or have a relationship with both parents, even if they are separated. Express their opinions and be listened to. We talked about the voice of the child. We talked about their having their privacy protected and their lives are not subjected to excessive interference. You know, government can't come up with all the laws in this country to how families and individuals need to operate, but surely we need to regulate, you know, the laws in society and to ensure that the children's rights are upheld. Having said that, you know, besides setting out, and you heard my colleagues mention it as well, your civil, political, economic, social, and cultural rights of children, the convention also affirms the fact that children, because of their vulnerability, requires the following: the need for legal and other protection of the child before and after birth. Now also critical is the importance to respect the cultural values of a child's community. The children need special care and protection. Special emphasis is placed on the primary caring and protective responsibility of the family. And you hear the judge mentioning fathers, mothers, and so forth, which is critical. And the role of international cooperation in securing children's rights. And therefore we have the convention, so that we have this buy-in from all countries, so in order how we will treat children within and across our boundaries. Now, you would know that South Africa has passed many laws in supporting the Convention of the Rights of the Child. But one law that gives credence to this more than any is the Children's Act 38 of 2005 as amended, is a primary domestic law aimed at giving effect to the children's rights. Now, colleagues, over the years you've heard and you've seen the amendments that has happened so that we become inclusive around the protection of children. Now, when you look at the objectives of the Children's Act, and this is in the Children's Act in terms of Section 2, you would notice that Section C of it says it gives effect to the Republic's obligation in concerning the well-being of children in terms of international instruments binding on the Republic. And one of the binding instruments is the Convention on the Rights of the Child. And then if you look at the best interests of the child, is obviously, it gives effect to the 54 articles that you see in the convention. And so every aspect which is the best interest of the child standard must be met when we deal with any matters of a child concerning the child, whether it's the care, protection, and rights of children that comes within the system. And it continues in terms of the best interest. Now, this is very important, and this is in the legislation itself. And this is part of our mantra that we have to sing or be part of, is that when it comes to the application of the Children's Act, the rights which the child has in terms of this act supplements the rights which the child has in terms of the Bill of Rights. And therefore, all organ of state in any sphere of government and all officials, employees, and representatives of the organ of state must, not may, must respect, promote, protect, and promote the rights of children contained in this act. And so obviously this act binds both natural or juristic person to an extent that is applicable, taking into account the nature of the right and the nature of the duty imposed by the right. So we know we don't have a choice, that whatever is in the legislation in terms of protection of children, in terms of their rights, we have no choice but to park and comply. And you know, when we said we talked about the best interest in all matters, it means that it's of utmost importance. In all matters, it's not just the mother's rights, the father's rights, the extended family, the community. It's we have to look at that child's rights. We got to zoom into that individual child. Okay, having said that, I want to pause here, because you see government is always, and correctly so, government must be held accountable, right? But let's just take a bird's eye view and just Gauteng, and then I'm representing Gauteng, right? So when you look at alternative care, And we talk about alternative care, which means that something happened in the family and the child has to be removed, okay, for whatever reason. Now, if you look at our alternative care, and I'm just going to mention some of the services. We talk about foster care, child and youth care centers. We talk about child protection organization and adoption services. I'm just going to zoom into those services. Now, when you look at foster care, we all know it's an alternative care placement outside the child's family, and in most cases, we look at related and unrelated. Just to say, just in Gauteng, we got 42,000 children in foster care. 42,000 children, just in this province. Look at the money that we spend, and it's us. Remember, it's not one department's money. It's societal money. We spend 1,180 rands per child in terms of a social grant, which comes to about 49 million, which times 12 gives you about 594 million and so forth in a year. There's just that service. Now, I'm not even talking about who needs to do the service, because that child needs to be monitored. You know, we come to you, we've got to extend orders, and. I'm not talking to the rest. Just going to give you that ball figure. Then let's look at child and youth care centers. Child and youth care centers, colleagues, for those that don't know, it's a children's home, school of industries, reform school, secure care, and temporary safe care. So look at that. At this stage, in Gauteng alone, we have 150 CYCCs, of which 9 is government and 141 is MPO run. Of that, at any given time, we have 4,500 children being placed in those facilities. At any given time, we fund per child, per month, 4,320 rands. Look at what it comes in a month, almost what you could say 20 million, times 12, 233 million in a year. Then if you look at our CPOs, our child protection organization, we can't do it alone. It's too big. So we have to have our partners, which is our MPO sector, but it's called the child protection organization, like your welfare agencies, your child welfares and so forth. And what do we do there? We have 87 that's directly accredited in this province, of which they get funded for their posts, their programs, and it's amount to millions. If you look at adoption services itself, same with our CPOs. We have private social workers and government, but we have now recently, you would know, there's been amendments to the legislation that allows government to render only national adoption services and not inter-country. And we don't do it it's at no cost. And obviously with CPOs it is a cost, and with private adoption social workers it is a cost. We fund, further to that, we regulate, and designate, accredit, and also register and monitor the sector. We also fund hundreds of many other MPOs. This is just a few CPOs. We have hundreds of CPOs that the department in this province funds. We are one of the biggest funders when it comes to MPOs. For all other services, for individuals and families within communities. Now, having said that, we understand it's our mandate, but we don't have a pit of money, colleagues, that year in and year out, that this money remains the same. But is the social problems growing? Because let's go back to alternative care. Is that the ideal? We need to have this conversation, and I'm hoping that this session here, Chairperson, would allow us to think beyond. Is alternative care the ideal for such children? Because let's start from the basics. And if we don't start from the basics, we will find our society in turmoil, let alone other countries. Because why? Parental and family care and protection, where is that? Because when you look in 2022, South Africa had estimated 20.9 million children under the age of 18. This represents approximately 34% of the country's total population, which is what at that stage was estimated about 62 million. According to the Human Sciences Research Council, most children in South Africa, over 60%, don't live with their biological fathers. This trend is linked to various factors, including parental separation, economic instability, and cultural and I want to pause on cultural practices, because if we don't call out the elephant in the room, if we don't talk the tough talk with each other, then we will find ourselves wanting. Because sometimes our cultural practices allow such to happen. We must embrace our culture, absolutely. But culture does not supersede the law. It does not. And therefore, when you look at the bigger question is, how do we ensure parents and families fulfill their roles? Because we're having more and more parents, because rightfully so, we're having abandonment. But why do we get to a point? Because even with those children, the 42,000 children, the 4,500 children that we have here, and many others, how many parents are actually being held accountable? How many do we actually hold accountable for abandonment and not fulfilling their roles? In reality, do we have a deterrent in this community, in our society? To say, parents, you know what? And the best part of it is that we have many laws to support. Don't get us wrong, we are there, we have to support. And our laws start with even before you have, even when you want to engage sexually. I mean, we have contraceptives being available to children from the age of 12 without parental consent. Abortion is illegal in this country, so you're having those options. But then you also have, and I'm not talking to those may fall pregnant because of rape, I'm talking about generally what happens. Because look at our statistics when it comes to child pregnancy in this country as well. Now, when we look at parents, and then you still give up your child, it's so easy to say, let's take your child. But which child wants to grow up in an institution? Which child don't want to belong to the family? And what makes it more difficult for us colleagues, and I expect the partners in this room to be standing up for this, is the fact that right now in this country we are sitting with a huge issue. We are talking about safe relinquishment versus anonymity. You heard about the baby savers practice, where you've heard, my goodness, and why I started there is life. Because we have laws in this country to say that everybody is entitled to life. And there's laws to say when you do something to somebody, you're going to be held accountable criminally, right? But let's look at this. We have the baby saver practice. You leave your baby and you can go. You put the baby in that box, you can disappear. Now, where is parental rights and responsibilities linked to that? Where is all those rights we mentioned in the convention? Where is that child's rights? Because once you leave me, there is nothing attaching me to my community, to my identity, to my family, to my extended family, to my father, and so forth. Because let's look at this, and this is what the department countrywide is sitting with. And the department stance is within this ambit, within the law. We are clear on the following. Mothers have a right to upfront state that they do not want their child and they want to relinquish their child. Mothers have a legal obligation to safely relinquish their child with families or alternately within the childcare system. However, relinquishing a child safely does not equate to wanting to remain anonymous. Anonymity of the mother equates to abandonment of the child due to the following. Even though the mother has a right to declare that she does not want a child, equally the child has a constitutional right to his or her mother, father, sibling, extended family members, culture, religion, community, nationality, and so forth. And this is enshrined in Section 7, which I just showed you just now. And Section 9 of the Children's Act states that the best interest of the child is of paramount importance. So in all matters, that child's rights need to be looked at. So you're going to ask me then, oh, but Ms. Naidu, you don't understand. This mother has been raped. This mother has gone through a lot. This mother, because of gender and so forth. Absolutely. We must be very careful as a society that when we're trying to resolve one issue, we do not compound another. Because what is then in place? Because that's the question you should be asking each other. And this is in place. The child care and protection services and resources available to a child and mother 24 hours, 7 days a week, 365 days a year, where the child care and protection system is facilitated through DSD, the Department of Social Development, our child protection organizations, the South African Police Services. They also have their national instructions on the Children's Act, which is number 3 of 2010, as well as hospitals. And 99.9% of the time, where do we start? We start with the hospitals because we give birth there. So leave your child, if you don't want your child, leave your child there. And we have engaged also with our sector partners, sector departments, where we've wrote to them and said, please, when a mother says she does not want a child, you must remove that child. Keep that child and call social services. But explain to the mother not to remain anonymous. We can keep the child because why? We have a legal obligation to meet the convention, to work with the mother, the father, the extended family members so that reunification can take place. Because that is then looking at the rights of the child. But in the meantime, up front, we need to secure this child because we don't want the mother to take this child, dump the child in the veldt, and then kill this child because that's not our aim. However, DSD and CPOs operates generally from Fridays from 7:30 to 4, while SAPs and the hospitals colleagues are working every day. So you have access to the service every day. Now, does it mean maybe our families don't know how their rights? So we've decided as Scouting to make sure awareness takes place, that parents, communities, individuals, our stakeholders, and our sector departments get to know what they're supposed to be doing and empower communities out there. But to say to have a baby saver, leave your child and disappear. And further to this, with all due respect, as much as we may have a convention for, where all other countries are signatories to, but I can tell you now, with our borders not being that secure, South Africa does not have the resources to take on problems of the world. We have our own problems, colleagues, that we are not dealing with. And therefore, then you can have the baby saver where it can be a gateway for Africa and the rest of the world to come and leave your children and disappear. But also, beyond that, I must also say to this house, we also don't want to create a supply pool of babies for adoption, and which we are seeing, it comes with a cost. So just bringing out that as well. So currently, that is the case, at the High Court with us, but we just want to give you another perspective. Having said that, in conclusion, after all that has been said and done, there's more said than done. And in my conclusion, and I like parting words to you, is that history will judge us by the difference we make in the everyday lives of children. The way we get started is to quit talking and let's begin doing. If you have knowledge, let others light the candle in it. Continuous improvement is better than delayed perfection. The trouble with the world is that laziness is seldom curable and never fatal. To avoid criticism, do nothing, say nothing, and be nothing. Doing the right thing is more important than doing the thing right. Where there is knowledge, there can be no insight. There can be no insight. And where there is no insight, there can be no knowledge. And colleagues, unfortunately, the definition of fool is knowing the truth, seeing the truth, but still believing the lies. Thank you.
Colleagues, under my stewardship, I shall not allow bias. You are bias seated there. You are going to clap 3 times for all the speakers. Because I should think you were introspecting on what she has said lastly. And then I was even afraid to come back here. Where do I fit in there? So you are going to clap 3 times for the 3 speakers who have spoken. And then I'm going to call Funo. We are going to take 10 minutes break, and we are going to have our last speaker, the chairperson of the Commission for Gender Equality, amongst the colleagues who are here. I see advocate has gone down. I should think she might be on her way to move. However, remember what Advocate Shafi has said. It is in our hand. He has made a clear call that, we work with pro bono. We also give time to pro bono. We also donate money to pro bono, those that we do have money. Lufuno, please do come. I did not hear the claps. Thank you very much. Thank you very much. Now, you know, where I'm coming from at the commission, discrimination, bias, prejudice are not allowed. Thank you very much. Can we take a 10-minute? I know I've never seen an audience like this. I am telling you, I'm not trying to flatter you. This is the reality. You are such scrumptious souls. So let's take 10 minutes break. And if I come back here, please don't let me down. And then we come back. Let's have tea. And then we come back here. After that, we have the last speaker. We engage. We go forward. And those that are at home, please do not turn that dial. I see the numbers are going up. Send those questions. There's someone sitting here who are going to help to answer those questions. I thank you, even at home. Thank you. Colleagues, Daphne, Lufuno, can you call colleagues to come back? I was asked by someone at the back, they're saying that, why are you prolonging the tea break, because the speakers are just exceptional. Colleagues, welcome back. And welcome back to those who are online. I've just received 2 messages so far. In fact, it's 3. One is from my son. He's calling his friends to listen. One of his friends says, "We see you are dead online." He says, "What's happening?" And I said, "Are you okay?" I said, "No, I'm fine. It's about that thing that I told you." So he said he's going to call his other friends. They've just gotten out of the class. They are going to listen in. And I said, "Oh, wonderful." Then the other one, it's a colleague of mine said, "I love it when you call us scrumptious souls." And the other one says, "These people," I just received, the other one is a call, said, "These people are so impactful. They know what they're talking about. I can't wait to hear Advocate Sepanya Mohale." I said, "You bet." That's what I said to the colleagues. So I'm glad that we are all back. We're T, and the program, I'm told by LC and Advocate LC and Margaret that, next time, my job as a neighbor is still safe. Colleagues, here is the resume of like I told you, their resumes are very short. The fourth speaker of the day amongst the speakers that are here, it's Advocate Nthabiseng Sepanya Mohale, and here's one common denominator, LLB and LLM. And constitutional and litigating human rights. In addition to a legal academic career, Advocate Sepanya Mohale holds a BA in social work, a postgraduate higher diploma in advanced social work practice, certificate in trauma counseling from Copenhagen, overseas. In 2017, she was appointed as a part-time commissioner in the Commission for Gender Equality, and subsequently appointed by the President of the Republic, His Excellency Matamela Cyril Ramaphosa, to be the chairperson of the Commission since 2023, 1st of March. She has several experience. Amongst others, she has worked at the National Prosecuting Authority. She has worked at the Department of Justice, and so many areas. During her employment in the National Prosecuting Authority, she worked as part of the founding team of the Tututela care center. And I feel, to me, it's very poignant. She also set up national to provide services to survivors and victims of gender-based violence in this regard. Some of her activism on human rights involvement include membership and organization and leadership roles in several, including Federation of Transvaal Women, FETRA, detainees' parents, support committees, concerned social workers, the United Democratic Front, Vets Student Society, and others. Advocates Sipanya Mukhale's focus throughout their career and mainly on the constitutional and human rights and social justice, with particular emphasis on gender equality, women empowerment, and anti-racism. Every speaker here is a perfect fit for the topic, unlike you have called me to come and speak. Ladies and gentlemen, I call and I give it to you, the chairperson of the Commission for Gender Equality, Advocate Ntabiseng Sipanya Mukhale. Thank you.
Good day, everyone. I actually thought of cheating a bit and saying all the other speakers took my points, but it looks like I won't get out of it. Thank you, Pro Bono Advocate Shafi and all the other partners to this who have invited the CGE. Am I supposed to hold? Okay. Who have invited the CGE to come. It actually is a very apt, what can I say, milestone. It's 30 years of the anniversary of the United Nations Convention on the Rights of the Child that the South Africa ratified. I think it was on the 16th of June, as it was pointed out earlier. But I think for us as South Africans, there is that feeling of we are at a place where we cannot outright celebrate. And this is not in my notes, sorry, you'll pardon me as I digress. Because so much has not gone well. So much has so not gone well that even our children cannot be sent to the shops. So much has so not gone well that even our children cannot wait for mommy at the school gate of a supposed private school. Things have so not gone well that even the uncles and aunties who used to send us to the shops from 3 houses away, we do not know anymore. We are now being taught not to trust anymore. We are scared of them. Our parents look at them with a funny eye. Basically, 30 years down the line, the lot of our children is not a pleasant one. I was once a child many years ago, and I know when I'm saying the lot of our children, because I walked from school, I think it was 7 kilometers or something to that effect. And there was never this fear that we have in this country now. So it actually is an anniversary that reflects that we reflect on where we have gone wrong, because definitely, without mincing my words, a lot of things have gone wrong. Judge Retief said something about all the work that they're doing, and one wonders, there's a system in place, the systems in place, the capable men and women in these structures. What is going on? We had Ms. Naidu come and say, in social development, these are the monies that we spend. So something is not right. And why I say this, I'm actually encouraging all of you when we walk out of here, now that the list of the esteemed people, and now we know that it's going to be the 15th of November or so, when we have the Indaba on how, what's happening in South Africa. Let's all go back and hustle to get into those dingxoxo. Otherwise, we are going to end up with another 30 years where we pretend all was well. This has been the most violent. This has been the most violent period. This has been the most violent 10 years, if one could say that, for our children. But it started as early as in 1992. I still want to understand how in 1992, UD Simelane was murdered in the name of she does not belong. As early as 1992, and to this day, it has not stopped. So this has been 30 years and even more of not roses. And I know we really want to talk about roses because the country has actually ratified all these instruments, which is impressive. But we need to go to a place where after the 15th of November, we can even recommend to the country that no, all of these things that you have ratified are not helping us. We in the CGE are ready to take that battle on. And I'll tell you why we've already taken it on. We have got a world-class athlete in this country who was told by an international body that because we do not recognize your gender, we are stopping you from running. And guess what? We came back and the country said, unfortunately, yes, we have ratified. So maybe that's where we should even go. To say, let's stop romanticizing. Someone else also said, I think it was Advocate Noko, that this is the most ratified instrument in the UN history. Yes, it is. But so is CEDAW, the Convention on the Elimination of Discrimination Against Women. But guess what? CEDAW, on the contrary, is the most reserved of the instruments in the UN. By reservation, it basically says countries say, okay, where do we sign? However, Article 1, 7, 14, and 28 are CISI. The next country says Article 5, 2, and 3 are CISI. You know, that kind of thing. CEDAW has become an instrument whose paper is not even visible, never mind the ink that has been used on that. And here we are as women, feeling the most vulnerable, the most unsafe in our country. So I'm saying that maybe out of this, Advocate Shafi, we should not even have a normal situation. Out of this gathering, we should say, thankfully the president yesterday, on the 10th, actually announced a process with regards to the convention or to the dialogue. And now we're starting a process where we say we want a voice in the dialogue. That voice must 1, 2, 3, 4, 5 with regards to children. We as the CGE will add 5, 6, 7, and 8 with regards to gender equality. But enough is enough with just talking and not doing anything. The opportunity arose yesterday, and I think we should take advantage of it. 1 minute, please. You see, I don't know these things. I should have had it there. Then just to come back to my topic, our issue is the intersectionality of gender and children's rights. There's no doubt that the intersectionality is glaring and clear and without question. The first is the fact that gender inequality has got its basis from patriarchy. And we know patriarchy is one of the first corrupt systems ever to inform mankind. It was a group of men who said, we are going to have a better situation than the rest of them. That's what corruption is all about. We're going to improve our lot at the expense of others. And that's where all this started. So we're looking at 5, 7, 10, 1,000 years ago, wherein children, especially the girl child, has actually been set aside. So the battle is a very, very difficult and long one because it's based on something that has been mainstreamed. It's based on something that has been so mainstreamed and so intertwined into the fabric of every society that we do not recognize it anymore. We do not know when we're being discriminated against. That is how patriarchy has to some extent succeeded. So we're operating against the backdrop of that. But with it, it has brought a lot of things. It has brought as I was saying, the status of the girl child as inferior, and therefore the girl child has to a large extent become a commodity. You can go and take a girl child and sell them and get money. You can go and take a girl child and sell them, not sell them and marry them, and at a certain age you can bring another one. It's called ukutwala. The other one, as we know, it's child trafficking. There's also the sexual exploitation and the sexual violence that we're experiencing in our schools. But when you look at all of that, it has got an element of the commodification of the girl child rather than children at large. In fact, when you look at the dynamics of how gangs start, thrive, and get sustained, it's actually that overemphasized in a very, very crude way the value of boys. They have somewhere where they belong, they have this, they have that. It's almost like it's a rite of passage, whereas with girls, it's not that. Yes, we know that it is wrong. That is why I was saying in a crude way, but that's what happens. Then when you look at how the girl child comes through, let's picture this situation. I am in some village in Kwakwa, and I get abducted. Those who don't know where Ralimati is, it's behind the door. That's where your parents will find you, and when they come with their uncles, etc. And that child is only 13 years old. And the 38-year-old man promises that I will wait until at least they reach full puberty, and by full puberty, I will see signals when they menstruate. Unfortunately, that night, after the parents have gone away and said, oh, maybe our daughter is in good hands, and maybe this is cultural, as you had pointed out, that child gets raped. They fall pregnant. They end up with 3 children by the age of 18, never to see school. Those children will never, ever get out of the cycle of poverty. Again, as you were saying, the 38-year-old man moves on. So the lot of the girl child is actually, tested in so many ways. But that girl child grows up to be an uneducated woman who gets left with these children in most cases to say, you will see what to do. Gets abused by the family themselves. And this is what we are supposed to be talking about. That's why I say, we need to hustle our way in. The family itself sees a domestic worker who is not educated. But guess what? The trauma of that young girl comes when I, as the 40-year-old mother, when they run to me, I say, Aibo, I thought you were married. So we abandon our children sometimes at the time when they need us the most. As if that is not enough, at some point when they grow older, because of the wound that they carry, they themselves become wounders, if ever there's a word like that. If there's none, I'm going to IP it after this. Afterwards, they themselves start wounding others, and so the circle goes. But the trauma of this young girl does not even stop when they are 50, 60, 70. Now in our communities, when they have Alzheimer's or dementia, we ourselves, the young boys and girls, accuse them of witchcraft. And we go and attack and assault them. And sometimes kill them. It has subsided, But in Limpopo, many years ago, when I was working at the Center for Study of Violence, we were doing studies there. Older women were being killed there. So I actually feel when we reflect on the 30 years, let's reflect on the lived experience of that child who was born in 1995. Today, they would be 30. Where would they be? Let's reflect on the lived experience of that child who, as a result of anything of their own doing, they've not been able to go to university. But having not gone to university, there are no jobs, because we sometimes don't even understand them, and we don't want them near us. We prefer other people because they are so violent and wounded and angry. We don't understand. We don't want them near us. So there's that cycle of this 30-year-old who is nowhere and society does not see them. That is why I think this dialogue is so frustrating for me. I wonder how many of us in that dialogue are going to see ourselves. And that is why it's important that we make sure that we see ourselves. But all that is part of what, unfortunately, we inherited. We inherited a society that was divided, that was reliant on violence, that was reliant on us and them, and we have not been able to come together in a way that we don't see each other as us and them. So how then do we rescue the next 30 years? The first thing would be education. Education, education, education. It's important that we end up with education, but no ordinary education, a non-gendered education, an education that actually says whatever your value, as captured in the preamble of the Constitution, that we, the people of South Africa, who are going to enhance the potential of each citizen. Education using that lens, that each and every one of us deserves that enhancement, as we have said in the Constitution. But also education that goes outside of what we are seeing now of us and them. Education that goes to affirmation, education that goes to Ubuntu, you are because I am, education that goes to the level of where do you want to go in life? There has to be a system that supports you, rather than the education that we're seeing now. But above all, the education that goes beyond identity. And why I say identity is because I'm coming back to this point that we're talking about. Our education, you are either a boy or a girl. Our education, if you are not a boy or a girl, despite Section 9.3 of the Constitution, you are open to bullying. Our education, if you do not fall into certain of the cracks, gives you 12 years of confusion. Because our children up to grade 12 tend to be confused if they do not belong to certain of the genders within our spectrum, despite that spectrum being recognized by the Constitution. So we need an education that moves away from that. But we also need an education that will give our children choices. I don't know how many of you watched the news some 2 days ago, where the cousin of the two girls somewhere in the Northern Cape, the cousin was swept by the water. And it was heartbreaking that these two young girls said, no, we are happy that they found her. We're happy that, somebody put effort into finding her. So we will close that chapter. We will bury her. To me, that was a barometer of such a traumatized society, that we are not traumatized by somebody having been taken by the water because they were holding on to the side off the bridge and they let go. We're just saying, let's bury them. They found her, let's bury them and close this chapter. And this is a 19 and a 21-year-old. So which means you are going to end up once again with young girls who are traumatized, and we walk away and we actually think, hey, make do of it. So it pained me that somebody's saying, at least they found her, we will close this chapter. So we are even a society where we don't mourn. We are a society where we are exhausted to demand. We are exhausted. But we are also a society, I think, that is exhausted to even say, because one good thing about South Africans, we do know what we want. We do know. But I think we are exhausted to over and over and over say it. So all I am saying is, we are not going to say it, government has got to do this. Let's look at what can I do? How can I change the little bit that I can do? Who is the girl child out there who needs me? Who is this young boy who needs me? Some of you may not be aware that Winnie Mandela herself took fellow comrades to task and said, how dare you say our children are the lost generation? Do something so that we do not have cycles of lost generation. Look at where we are now. We've got nyaupe boys and girls. Shame on us. I'm sorry to sound a bit brutal, but that's what it is. At that time, once again, the media was like, oh no, it's you again. You're causing trouble. There was truth in that. Now we've got generations that are lost because we embraced loss or lostlessness. That's a second word there I'm going to IP. As though, it's their lot. But how we got here is because, lastly, this is my last point, we tend as South Africans, despite the community that we know we can be and the community that we always live up to, sometimes we reduce ourselves to, that's not my problem. That's not my problem. That's a white woman being manhandled there. That's not my problem. That's a black young boy being manhandled. That's not my problem. Or, they're disabled. That's not my problem. How can, in this time and age, somebody still be wearing a lipstick when they're a man? We always want to move away from that. And that is where we lose each other. And I think that is where we have lost in the last 30 years, despite all the good ratifications that Advocate Nuku talked about, the young girls. The biggest danger that we ought to be worried about, each and every one of us, is this 30-year-old who has got these 3 kids, whose husband now says, I don't even remember that we had children, who have got to go to court to get maintenance and all of that. In 30 years' time, will we be proud to actually say, as a 60-year-old, we did justice by them? Their children will be 30, 28, and 26. Who will they be? With those few words, ladies and gentlemen, thank you very much.
Thank you, colleagues, and thank you, Advocate Sipanya Mokale. While you were talking, you were asking that brutal question. I heard behind me, yes. It's just like people were praying. And then you are saying the right thing. So I said, I'm not at church. Let me be careful what I'm going to say. But I heard people, in agreement with you. And also, Advocate Sipanya Mokale, you answered that question, which Ms. Daphne Naidu has raised. Who are we? Who are you? And then you raised that poignantly, nicely. I wish Your presentation can be translated in all 12 languages. All of you sitting here, from Judge, from Advocate Noko to Ms. Daphne, in all 12 12 languages. That people, and we play your DVDs when we go to Texas. We play your DVDs inside the buses. Maybe somehow we'll get the message. Because to me, it was very profound. And we're grateful for that presentation. It was very, like I've said at home, those who are streaming live, you haven't witnessed anything. Here are the speakers to call the events, not those that are not capacitated, but impactful people are sitting next to me, and including Advocate Nok. Lufuno, before I say a lot, I was just mesmerized by the presentations. Advocate Chavi, I was mesmerized. Advocate Spanyamukale, this is from Pro Bono to say thank you. We'll call upon you again. Colleagues, at 1 o'clock, exactly at 1 o'clock, Margaret has said to me, we are going to have a choir and we are going to engage. Can we start engaging now, because it's not about me? Can you engage the speakers here? But there's one question that came from online. I'm not directing it to anyone. It says, from Nolutando, says, when is the global judicial system going to accommodate African laws? Amasikwe esizwe. For the well-being of African child. When is the justice system going to take seriously the DNA of the African child? That is Nolutando online, asking a question to the legal people and to Ms. Daphne. You have got mics before you.
Understand it, because the answer lies within the borders of the Republic of South Africa. So I'm not really understanding the question. I'm kind of vexed in a way that perhaps the person who posed the question doesn't quite understand what they have right here at home. So
let me repeat.
yes, you may say.
When is the global judicial system going to accommodate African laws?
What global judicial system do you think the person refers to?
For
I'm
the
not
well-being,
sure.
for the well-being of an African child. When is the justice system going to take seriously the DNA of the African child?
Well, I suppose, in short, not knowing what the person is referring to as a global judicial system, because each country has their own judiciary, and depending on the type of country, and in a democratic society, it forms part of the third arm of governing, but is completely separate to executive and legislative. That child can come to our judiciary. Insofar as we have any impact which flows beyond our borders, we look to the treaties which are in place, and that is the answer. So it is in place, and I'm not entirely sure what rights the particular person wants to exercise. But I can take it no further than that, I'm afraid.
Thank you very much, Judge. Ms. Daphne?
I think just looking at that question, the thing is, the good news is that our Constitution protects all children, whether you are a South African citizen or not, whether you are an unaccompanied separate migrant child in South Africa, our laws protect all children. So when you take from an African perspective, it's an African perspective, the Ubuntu-ness, the fact that our laws protect all children, irrespective of your nationality, irrespective of the fact of how you have landed in the country, we protect you. And therefore, we really embrace the Africanness in terms of that. I think from a cultural perspective, that's another issue. And that is already embedded in our laws, because we do take that into consideration whenever we look at the rights of the child and the child's care, protection, and also rights. Thank you.
Thank you. Advocate?
Mr. Baloy, I'll just be brief. Be brief and say, under normal circumstances, justice is supposed to be blind. Justice ought to be blind. That is why Lady Justice's eyes are covered. So maybe the question should actually be, at what point is the burden, the skewed burden on the shoulders of the African child going to lessen? And for it to lessen, there is where we should be looking. Why is it not lessening? Why is it not decreasing? That's the word. In fact, I must write a dictionary. I can see I'm getting good at this. Why is it not decreasing? Because justice has got to be blind. It's not supposed to look at color. But we are moving from different points of departure. And why is it still so 30 years later? Thanks.
Colleagues, before I read another one that is coming through the chat, is there someone here? I know all of you have got questions, you have got input, comments. I see a hand there at the back. Can we have a roving mic? Okay, you will say.
Thank you so much, Javu. My question to the panel is, how can we ensure that rural children are not forgotten? In the sense that we still have schools that use pit latrine toilets to this day, although there is a court judgment to that effect. And seemingly there is a lack of a political will to tackle issues that affect the rural child. Children in rural areas still have to cross dams and rivers to get to school. Children in rural areas still use pit latrine toilets. Children with disabilities in rural areas are not catered for. They have to stay with their mothers because there are no special schools that cater for rural areas. How can we then ensure that the rural child is not left behind? Thank you.
Thank you very much. Please, I forgot to say, please, maybe you say your name and the institution that you represent. If it's in a personal capacity, you say so. The one that has spoken, I know your name. Your name is Notemba Sonjika, so I will mention your name. And she called me Jabu when everyone was calling me Mr. Baloi. Another hand before this wonderful panel answers. My sister over there.
Thank you. My name is Mamiki Ramapakela. I'm from Gauteng Children's Rights Committee. My comment is based on different themes that were presented by different speakers, the 4 speakers that were there. But the common thing that I was picking up, sitting here and being an organization that works at the grassroots in Gauteng, whereby you come across the cold face of children's rights being violated at all costs. There's a serious problem of systems failure. We can have so many good international treaties. We can have so many laws that are meant to protect children. But in terms of those laws, those policies being implemented through the systems that we have in the country, there's a lot of gaps, there's a lot of systems failures. So I would like to challenge, the speakers here, even the organizers, that maybe from this recognition of this 30th anniversary on the UN Convention of the Rights of Children, moving forward, one of the things that we really have to sit down as all stakeholders is to interrogate the systems that we have in this country before we can even think about how does that affect internationally as well as regionally. We have serious problems. I mean, it's so painful to come across a situation whereby a father has raped three of his children. And when you take a matter, I'm a social worker by profession, when you take the matter through the system, one of the things that we are facing is that, you get a docket being sold or being bought at 5,000 rand. Is the child's life worth 5,000 rand that a police person who's supposed to investigate and protect this child worth the child's life? So I'll be very, very much happy if we can start interrogating the systems that we have in this country for protection of children.
Okay, thank you. Let's not get a question from the floor now, because the choir that I promise you I'll be conducting is about to come in. Let me, my learned colleagues here and Ms. Daphne answer the question. The third one, advocate and judge, and Ms. Daphne, from an advocate online. Advocate Matwiki, here, does one have to be accredited to deal with children's matters? Yeah, this one is straightforward. Maybe you can, from the rural children crossing those bridges, and the comment from my sister, and from advocate. The floor is yours.
Yes, thank you. I'm going to. All right. Let's just start by the first one, which is the rural. Strangely enough, it flows beautifully into the lady that is the social worker, because actually the same problem is a foundation issue. In other words, it's a systems issue. And I say that simply because the first young lady who said the problem with the rural children, who's going to see their needs, the first thing you said in your preamble when you opened was that you had gone to court, and that you had received a court order and retribution. But notwithstanding that, nothing really happens. Schools are falling apart. There isn't lavatories, etc., and we can go on and on and on. So in effect, what we are saying, which comes out beautifully by both ladies, is that it's not so much, and I'm not saying the high end of the system, I'm saying that the foundation of the system is there, but unfortunately, it's all collapsing. So it's really got nothing to do with, should I say this, the courts, but they gave you what you required. The implementation of it is out of their hands, but the lady next to you, the social worker, highlighted it beautifully, that in effect cannot be given to something which is not there. And that, I think, if that answers your question as far as the court's role in the protection is concerned. Insofar as the young gentleman or the advocate, there is no accreditation. In other words, if he is an advocate and he is practicing and he wishes to practice in that area of law, he can, without any fear or reservation, do so. It's as simple as that.
Thank you. I think I have a different point with regards to the two questions from the ladies there. You know, and rightfully so, South Africa's got beautiful laws, and the implementation is where we fail. But also, where does the court come in to hold people accountable when something does not go right? Or to when there is an order and there's no adherence to that order? You know, it's also what I talked about when holding parents accountable. How do we say to them, look, you can't just say you can't do something. Now, those systematic issues doesn't mean that when you get to the ground root, it's truth be told, the Constitution tells us a lot of things that we are entitled to. But in reality, like for example, everyone is entitled to a house. In reality, you know, the state cannot provide everyone a house. So the question is, it doesn't mean that we must stop just because we have the police official, for example, that has been taking the bribe. You're going to get those that fail, but let's look at the successes that happen when we have these systems that do work. Absolutely, I agree. There are certain times when we need to review systems. You know, we need to go back to the basics to see whether something works or not. But we have to deal with it on a day-to-day basis. Now, what I've done in my sphere is to not just empower stakeholders, because when you start empowering your local people, your community leaders, your community members, then they can start holding us as public servants and so forth accountable for the service that they require. Sometimes empowerment needs to happen the other way around to get us to do what we need to do. And political will, I think we all have, we know where it knocks really hard when it comes to those issues during elections. Thank you.
For me, I would just like to briefly say the biggest opportunity that we lost as a country was that we did not see the Constitution as our second other Bible, because our Constitution has got beautiful values that has set for us as a country. That's the first thing. But our Constitution, I think it's 9.4 or 9.5, talks about the horizontal responsibility of individuals towards each other. We focus too much on 7.2, which says the state must promote, protect. Whereas we were supposed to have been looking at, what does this mean for me? When you are a company and a constitution says, as a juristic person, you've got a duty and a responsibility and rights. What does it mean? As individuals, you know, all of those sorts of things. Because somewhere things fell apart. At some point when Minister Kara Asmal, I'm just giving away my age there, but don't worry, I read about it. I'm not that old. When he was Minister of Water Affairs, we were at 85% provision of water in individual households. And then at some point, I don't know who was leading that portfolio, we were at 2 million units of houses. Yes, they are not of any value in so many ways. You know, they undermine Section 10 when you look at human dignity. But we were at 2 million units. How we got to that poor quality of structure is another thing. But this government could build 2 million and provide 85%. We've got a minister in a portfolio. What's that thing that we used to bargain for? Load shedding is, you know, you get shocked to say, no lights. No, it can't be load shedding. We don't have load shedding anymore. Which means we can, if we want to, we're able and capable. So all the backlogs are actually issues that we must bring to the fore to say, how did we get here? That must be the question. How did we get here? Because we can. We are better than that. Thanks.
Thank you. Yes, a round of applause again to... I see there was one person who did not clap. Lunch you're not going to get. I saw that. Thank you very much. You can sit comfortable this side now so that you can also enjoy me, see me doing my things. Thank you very much. Thank you very much. Yes, thank you very much.
Good afternoon, everyone. Thank you so much. It's a really big honor for us. We're the Kantare Children's Choir. Not all of us. Our choir is about 80 children, so this is definitely not everybody, but it's a wonderful opportunity for us to sing for you. And what better occasion to showcase what the future of South Africa holds. So we are going to start. I'm going to accompany today. I'm Christelle Engelbrecht, and this is my co-conductor, Andrew Jans van Rensburg. And we are going to do a few songs for you to entertain you for a bit, starting with a cycle called Bless the Lord. And basically it's all about, doesn't matter which kind of animal you are, or if you're a butterfly or a moth, or if you're a granny or a granddad or an uncle or an aunt, you will bless the Lord. Okay, and then I will announce the next song after that. the next song is quite popular in the choral world. So if you know the name John Rutter, you will know he composed something called All Things Bright and Beautiful. So the next song is fun, and it's about a really naughty little boy whose dad wanted him to be a musician, and all he wanted to do was build go-karts.
Had a lovely little go-kart. He took it out without a word.
we have fruit salads. We spice things up. Bananas are in the middle, peaches on this side, and pears on the other side. See, even me, I forget. So this next song is about a boy who's trying to catch a train, and yeah, he's just running for his life. And then our last song is Cantamos, and it translates into we sing. We sing.
and the young ones. That was exceptionally beautiful. It's unfortunately, I'm part of you. I've been telling them here. I've been relegated because of slight touch of flu. So we'll be playing somewhere again next time. Yes. Thank you very much. Thank you, Margaret, Daphne, Rufuno, Advocate Shafi, and Advocate Elsie. I never knew when you say the choir, they sings beautiful like this. Can we go for a short break? We go for, it's lunchtime now, and I'm so grateful you are still here. What's gonna come up next, it will blow your mind. Because the three speakers we're here, they still have to answer questions from the people at home. We will never forget you at home. The questions that are coming, Judge, Advocate Sipanya Mohale, and Ms. Daphne, there are people who are asking very good, poignant, and wonderful questions. So let us make them happy at home, because I promise them that today it's about them, it's not about me. Thank you. Let's have lunch. I know this group here, we don't take long. We will come back fast. I won't put time limit for you. Thank you very much. Oh, colleagues, colleagues, thank you so very much for coming back on time. I knew I don't have to tell you we should come back at, after 30 minutes or 45 minutes. I knew it was gonna come all right. We are joined by a royal family, the Mzilikazi royal family, if I'm not mistaken. They also have a question. And welcome back online. We're still streaming live from Facebook and YouTube, Commission for Gender Equality. And we're still receiving questions from online. We have decided by popular demand, and because, you know, we are a listening cohort of people, more especially from Pro Bono, the program leaders, to say we are going to stop engaging on the issues of provincial observation, because people who are seated here and online, they say they can't get enough of the responses that are affirming, that are forward-looking from the panelists. However, now we are likely to be joined in the question and answer session by Advocate Shafi. So that, because Judge has left, Advocate Noko has left, because of prayer arrangements. So we apologize back home, and we apologize in here. We knew that they will leave early, but what we have left with is adolescents. There are questions that have been sent to us, and I need the family to, the royal family to ask the question because protocol dictates that we must respect royal families. I do not want to lose my stand back home in Guyana. The questions are as follows. One of the questions says, "Hi Jabu, please ask this question for me. You are a caregiver to a child with disability and DSDs looking at your pay slip. They say you cannot qualify to get a disability grant for that child. Why? Because that child is not yours, you are helping. And when you are a caregiver, you no longer get even a foster care grant because you're a caregiver." That's the question. Number two question, which came from online, it seems as though abandonment and/or relinquishing of the child lays solely or is rather specific to that being an act done by mother of the child, not the father. Will this not qualify as discrimination? I think this person who wrote this question is a lawyer. Things like and/or are basically lawyers. And so I'll hand over the mic to the three colleagues. We are joined by advocate again. Yes, the mic, and then we'll give it to,
All protocol observed, and good afternoon. We had a lovely discussion this morning, food for thought, and then we had a lovely lunch, which was food for the soul and the stomach. And now we're back in the graveyard session, as they say, after lunch. But we're going to make it as exciting as possible, because that's what a symposium is all about. It's just by way of comment, Chabu. It's not a conference. A conference to me is a talk shop. You meet to meet, you resolve to resolve, and nothing gets done. But in the symposium like this, you're basically reflecting, you're listening to the experts, and then you say, you know what, we need to leave a legacy for posterity, for our children. And what was nice about it was that before we broke for lunch, we had our children here. And through their innocent eyes, we saw a world that reminded us all that once upon a time we were also children. And what is it that we want to leave for our children? A rich legacy or a world full of nightmares? And I think that to me is the essence of what we're walking away with here today. So these two questions that you're asking for, the caregiver of the child and the disability grant, I think that one, I'm going to say that the DSD perhaps can be better positioned to answer that one. But we take note of the important question that they ask. The second one about abandoning of the child, whether it's the mother or father. And that's the problem we're facing in our society today. Let's forget about whether it's discrimination or not discrimination. Abandoning of a child should never happen. If you look at the spirit of the Constitution and the principles of Ubuntu, we are saying that no child should ever be abandoned. That's the first thing. Because in our societies, children need to be loved and cherished and be given their ideals to grow up in a world that is free of all the stresses that they face today. So it goes beyond the question of discrimination. You can't play the blame game, you see. You don't make the problem of the father and the mother the problem of the child. Because when the child grows up, he's going to grow up with, or she's going to grow up with stigmas attached to it. And it carries on for generations. So I think, in as much as the question is relevant, we know our rights. There are only 27 rights in the Bill of Rights. Civil and political rights, and the others are socio-economic rights. But all 27 rights are geared towards the protection, promotion of the rights of the children. The reason why we call this symposium today was to remind ourselves that the ideals of the Constitution are being challenged, and we are all searching for solutions. The solutions are there. The question is, how do we implement them as well? So these are important questions because this is a rights-based society. And in the rights-based society, everybody has rights. And within the framework of those rights, we can get into a better situation than we found ourselves in. And that's why we have these kind of challenges. I'll stop there and I'll hand over to the chairperson of the CG to basically take the conversation forward if she wants to. Thank you very much. So maybe I need to pass the mic on to Daphne. Thank you very much.
You want to advocate to move around? No, she has to answer. There's a question for DSD. Rufuno, can you come? Thank you very much.
Yeah, SASA is a entity linked to Department of Social Development, absolutely. Colleagues, when it comes to social grants, we use the Social Assistance Act that defines the various social aid that one will get. Now, remember when we talk about disability of children, and depending on the severity of that disability, some children will then need full-time care by a caregiver or parent, what have you. So they can be entitled to a care dependency grant on top of their disability grant, which is almost, in fact, it's the same amount. I think it's just over 2,000 that they can get both the grants at the same time. Now we're talking about children. So once that person becomes an adult, which means reaches the age of maturity from 18, that person still is entitled to a disability grant, but not necessarily the care dependency. Because then the care dependency grant is converted into a grant in aid, which means that the person can still get another person to care for the person, but it's a grant in aid and the amount is then lowered. But please also understand that the Social Assistance Acts use different means tests, because when it comes to disability itself, it's about the primary person that needs the care and not necessarily the person that needs to provide the care. So I'm not sure where they have gone to, or what SASA officers they've gone to, but I suggest that when they do meet officials from SASA, they don't just hear from that person at the front desk. If they're not satisfied, they need to then say, I need to speak to your manager, or I need to speak to somebody that I have an alternative view, and so that whatever you have said to me is backed up. And then maybe go to the nearest DSD offices where you have your social workers to engage accordingly. So that is in terms of your social grants with the child being disabled. But let me bring the other issue and think about abandonment, and this is very important. Remember, firstly, let's talk about parental rights and responsibilities. And I think lots of times we have used culture to define that relationship. Because especially, and let's be honest, especially ladies, because we know you are the one that carries the child. And for some odd reason, in society, most of us are under this impression that just because I had carried this child and I give birth to this child, because the man does not provide for the lobola or damages, there is no rights given to that father of that child. And we are mistaken by that. That's the first thing. Because if you can prove that you are indeed the father of the child, then you have equal standing in terms of being a parent to the child, even if you are not in a marital relationship, whether customary or civil. That's the first thing. Then secondly, if you look at abandonment, and that's exactly what I was bringing the point out earlier. The starting point is we should have no child being abandoned, because the law, in terms of parental rights and responsibilities, afford you a legal obligation to take care of your child. If you, as a parent, is not able to do so, it means that we can always assist. You come to the various, entities, DSD or whoever, to say, how can you assist me so that I can retain this child in this family? Because if you look at the child's rights, the child has a right, a fundamental right to you as a mother, to you as a father, to you as an extended family member. So equally so, when the mother does abandon, and I think sometimes there's this syndrome of, it's mine, I own, and therefore I shall do what I think should happen. And I think a lot of times we don't realize that it's not you alone in this, and that there are family members that have rights as well towards this child. And as best, the ultimate would be place the child in alternative care if we cannot find family members, so that we can relook at services to reunify that child. Absolutely. Culture has given us this thinking that it's mine and therefore I can do what I need to do. It's not just discrimination. I think it's beyond discrimination. I think it's the way we look at things, in terms of how we engage each other. And also, let me put in the same light, the relationship between the mother and father sometimes defines the relationship between the person and the child. Because we did not marry, because I didn't pay lobola, because I didn't pay damages, because we did not get married customary or civil, and therefore I believe I don't have an obligation towards that child. That's the other issue that we need to tackle. Because whether you gave, well, if you gave illegally, then obviously you have no rights. The rights can be taken away from you. But if you gave legally and you made the child, you shall and you must be accountable for that child as well. Thank you.
Thank you, Ms. Naidu. The person is super happy with the feedback. I've gotten an answer here. Thank you. And they said they will take this matter. Should they not get recourse, they will take it to the Commission for Gender Equality to be assisted further. It's in writing. And thank you very much. The royal family that wanted to put me off my land.
I would like to thank for you for giving me this chance to speak in front of all these people who are here. My name is Mbuso Ngwenya, induna under Mzilikazi Royal. I came here just because we have a serious problem which is affecting our people. As you know that Mzilikazi kingship is mostly outside South Africa and here in South Africa. As you know that Mzilikazi left here from South Africa to Zimbabwe. Therefore, we've got a lot of people who came here to South Africa because of different reasons. Most of them are politically, whereby our people were being killed in our country, and it's forced them to run away from our country from the years like from 80s up to now. And those people, when they come to South Africa, they start having the children in South Africa. And those children, up to today, they are having a problem of documentation. There are people who came here and they managed to have the South African IDs illegally. And those people, they gave birth to children that using those ID books. And during the time of Minister Nkosazana Dlamini Zuma, she gave amnesty to those people who are using those South African IDs to bring them back to the government, and they will be given the amnesty. When those people brought back those ID books, those children were left with no nation. Like right now, they don't have the identity documents. Some of them, they can't even continue with their education. They can't go to university. Most of them, they can learn maybe from the basic education. But when it comes to the time of where they're supposed to go to the higher education, they can't manage because of documentation. I'm talking that because of the court ruling that comes saying every children which were born here in South Africa, they've got a right when reaching 18 years to choose whether they want to be citizens of South Africa or for their parents' countries. But what I can tell you, those children, even if they can use those documents or choose to be their parents' nationality, the problem that side, they can't allow them to work because they don't recognize the South African education. So my question is like, it's a request or I'm pleading that please, as the lawyers of human rights, please try to help our children so that they can have the proper document so that they can continue with their education. My second question, I heard that I have given only 2 questions, but the problem, I've got a lot here. There are parents who gave birth to children here, and those parents were undocumented. And now those children have lived in South Africa for many years, some they are even 30 years and downwards. And those children, because their parents, they don't have the proper documents, they can't go to Home Affairs and given the chance to have the documents. I can tell you the children, some of them, they are even planning to commit suicide because they can see that their future is very, very dark. So I'm pleading with those who, on authorities, to look at on that matter, because I'm telling you that there are many children. I mean, here, there are people who report almost every day that their children, they've passed matric, but they can't. There are some who can't even start their basic education, because even now the schools, they start to ask for the documents. Of course, here we can agree that the law agrees, but when you go to the school, you find them saying the other things. Even at the Home Affairs, please, can you try to do the follow-up, because even those of 18 years, who have reached 18 years, they can't give them those documentation. There are few of them that have go through that way of application that have successfully get those documents. So I'm here to ask for your help, that please look for my people if we can get help from that kind of difficulty that we are facing. Thank you.
Maitabase. It means thank you. I want to help you in this way. Since you asking questions which are poignant, maybe I would rather have you talk to social development, because it's a direct issues that are affecting the kids. It's the little wisdom that I want to apply. And also someone from Pro Bono, because you are humbling, you are pleading with them to assist you. And if it relates to the mandate of the Commission or Human Rights and CRL Commission here, but on that score, I'll also give it to Ms. Daphne to be short, so that even other people can have a chance, because I realize he has raised a lot of issues there, though it were 2 questions. So will it suffice with you, Nkosiam? There's someone from CRL, there's someone from CGE, there's someone from Pro Bono, there's someone from Human Rights Commission. So we can talk to you and see where it's relevant. If it has to go to Home Affairs, if it has to go, they will point you to the right direction. But in the interim, shortly, so that we also get other people chance, and so that we can move forward with the program. Ms. Daphne will answer the question shortly, briefly. Thank you.
I may not directly answer that question, but I would like to talk to the issues that he just raised. Because in this country, we do have unaccompanied migrant separate children. And certainly, like we said, our constitution is very embracing. It protects all children. But let me make this very clear. Being born in this country, especially to parents that are not non-South African, does not make you automatically a citizen in this country. That's the first thing. Secondly, if you're not in need of care and protection, and therefore if we if we do have anyone that has entered the borders without the proper documentation, then you are illegal in the country. And South African law then says that that person should most likely be deported. Now, if that child is not found to be in need of care and protection, that child will be deported with the parent to their country of origin. But when we do find unaccompanied migrant separate children in this country, I can guarantee you that because we have signed international treaties and conventions and so forth, we have a duty to each other as countries to say that let us work together. We do work with ISS, it's an International Social Services within Department of Social Development, where we have agreements with, we work closely with the embassies and the consulates and so forth to look at repatriating such children back into their countries. Obviously, we have to prove that this child comes from that country, and that country must also agree, indeed, this is their child, and they will work within that welfare system of that country to ensure the child is repatriated. But I think this is a few things in terms of, children and children's rights, but it's also limited in terms of the law, what should and cannot be done. But certainly, if something that we need to look at, we will look at that case if needs be. Thank you.
Thank you, Ms. Daphne. By show of hands, so that we move with speed. 1, 2, in that order. I did not see the third hand. Indeed, it's a graveyard session.
Thank you, leadership. I'm Reverend Khololo from Faith-Based Organization in Gauteng. I just want to find out 2 questions. I think I missed this one. I've seen somewhere where they say there is crisis in Gauteng DSD in terms of distributing the money, and to the point that some of our centers might close down. So I'm just interested in that part as to how do we handle that, because I've been receiving calls from some of the centers. And then the last one is collaboration. As the church, or maybe faith-based organization, we really always requesting to work with a lot of sectors, but unfortunately many people take us as people that open in prayer and close in prayer. So they never want to collaborate with us. When they plan alone, and they just bring us to mobilize. So I'm just pleading with sectors that are here, because we have a lot of children that are in need, so we can work together. Can I say God bless you?
So a hand that side. Oh, okay. Thank you very much. Please do respond.
Thanks. Thank you.
Thank you, Daphne.
Okay, so the issue of Section 4.3, which relates to citizenship for children born to parents who are foreign nationals, is a critical issue, because it was instituted or brought about in 2010 to prevent statelessness. And Parliament recognized the children born in South Africa who haven't gone to their parents' countries of origin effectively are part of the society of South Africa. And so when they reach 18, they then become at the risk of statelessness, because their parents' country of origin don't necessarily recognize them as citizens, and South Africa also doesn't recognize them as citizens. And so in order to deal with this issue, they brought about Section 4.3. So you'd have to consult with each client, but if a child is born in South Africa, 2 parents, regardless of their nationality, and they've stayed in South Africa until they've turned 18, they can apply for citizenship. So yes, the law does state that you aren't automatically a citizen when you're born in South Africa, but when you turn 18, you can apply. And the courts have said, through the Western Cape High Court, the Pretoria High Court, the Supreme Court of Appeal, they have said that citizenship is a matter of law. And so there's no discretion in terms of when a client or an applicant meets that criteria, there's no discretion as to whether or not they should get citizenship. So they have the right to apply for citizenship at 18, and they have the right to be granted citizenship 18. Because the reality is that there's no recourse for that child after they turn 18. And then we sit with the issue where people are xenophobic and they say you must go back to a country that you've never been in, that you have no ties to, and what becomes of that child's future that we want to protect, right? And the problem is also the Department of Home Affairs, and I wish they were in the room. Because the issue of documentation is so essentially linked to the rights of children. And the department is not seeing their role in creating and causing barriers to rights. We have so many court cases which deals with birth registration, right? We have pending litigation now that the LRC brought in trying to recognize the fact that children need to be registered regardless of their parents' nationality. It's their right, it's in the Constitution. A birth certificate does not translate into citizenship, but their births must be documented. They get an unabridged birth certificate, handwritten, with no ID number on. And that birth certificate essentially gives them access to healthcare, education, etc. So it's important that they need to be documented. And so we need to get Home Affairs in the room to understand that this administrative process is not going to open the floodgates, as they like to say. Because even when we have judgment from the Constitutional Court which says that fathers are entitled to now register their children's birth, Home Affairs comes back and says, okay, but you now need to do a DNA test that costs upward of 1.5. Who's going to afford that? So we need Home Affairs in the room. Documentation is an issue, but citizenship for those children are also vital. And we need to take it to the courts, and we need to take it to the streets. And we need to ensure that the systems that should be in place are working effectively for the children.
I have no regret whatsoever for giving a chance. You know, my mouth was open and said, you sat there with such wonderful details. Thank you very much, my sister. But before you answer, Ms. Daphne, there's, for that question that was asked by the Reverend next to you, there's a question online. Aye? It's Nolutando again. Okay, they're not picking up. Our controller will help us as soon and when and if she comes back online. Ms. Naidu, please, I'm sorry to put you on the spot.
I realize, yeah, I'm coming from the state in DSD, so I'm prepared. Okay, my colleague here from a faith-based organization is talking about fundings of the MPO, and some of the organizations are affected. Let me make this very clear, and I think sometimes the narrative that goes out there can be very skewed. Colleagues, we have a sector and our partners, and we have a lot of fly-by-night organizations. And then the next thing, you want to hold government accountable to say the quality of the services has been, something that needs to be looked at. So as a result, we had to go back and look at the impact, look at these organizations that have been in place. Some of them have said to us, but Ms. Naidu, we've been in place for years and nothing was done to us. So sometimes, when we get to know the right, it means doing the right going forward. So you would notice that the funding issue was a huge issue. There were a lot of investigations previously. The MEC has come out, given feedback on the process that has unfolded, and explained that the few that have not been given the funding, and it's a few, there is a process of appeal which that they needed to undergo, and the reasons will then be articulated for them or to them if they were not successful in terms of their funding or their registration or their accreditation or the designation for that matter. So I think that's where it is. It's not whereby there's just a shutdown of any organizations. So if there is such, there was valid reasons So the organization must provide you the reason that they would have been provided from the department itself. Thank you. Oh, sorry, and then maybe just one more thing. You were talking about the faith-based organization. Can I just say this? The faith-based organization is the fundamental organization that talks to not the art core, because we were talking about, and I think one of my questions earlier on, Chair, was let's get back to basics. And the basics comes from the faith-based organizations, because our value sets as individuals and as families comes from faith-based. And if we can go back to that, because you are an important sector that can bring us back to the basics. So absolutely, and if you look at Section 110 of the Children's Act, in terms of mandatory reporting of abuse of a child, there's 4 aspects of whether there's spiritual leaders, pastors, and so forth. They're mentioned in terms of reporting of abuse. So that sector is critical in becoming, becoming an oversight about child and child protection out there in society as well. Thank you.
Thank you. Colleagues, looking at the time and also not wanting to destroy this wonderful symposium, I will want to thank you for tolerating me today. I want to thank you for thanking me in the morning. I want to thank you for being patient, calm, respectful when engaging, robust in a way with the questions, and listening attentively to the 4 speakers whom I'm told I have to be their agent. Because wherever they are going to be called to go and to speak, you have to go through me. I have to charge a service fee, because what someone was saying, what you are saying about this, you were not mistaken at all. They were very marvelous, all of them. A big round of applause to our speakers. And on that note, I have to call the National Director of ProBono.org. And I also want to thank my colleagues from Pro Bono, LC, Daphne Rufuno, Margaret, whom I work with. I want to thank TAT, Notemba, Lesijo, and Silo Mkateko, Dr. Matotoka, whom we were working with throughout. So I thank you guys, and I appreciate the opportunity. I'm humbled and honored. This, to me, I don't take it for granted. Chairperson from the Commission, I appreciate you greatly. Advocate Chavi, I appreciate you. I won't be coming back here. Please, I give you the mic. I'm not coming back here. My job is done. Thank you.
Thank you.
Thank you very much.
Thank you, Jabu, for
Thank
the
you.
job well done. Esteemed colleagues, it has been a wonderful symposium. Don't you agree with me? So, thank you to everybody who made this a success. You know, as we were, just before lunch, when the children came to the fore and sang, I don't know about you, but this is what it kind of resonated with me. That's the world I'd like to see children in. Because that's the world we come from. And so as a legacy, we owe it to them to create a world, a better world for them and for posterity and for generations to come. And it goes beyond the letter of the law. It goes beyond the International Convention on the Rights of the Child. It goes beyond the Constitution and the preamble of the Constitution. And it goes beyond the blame game. I think in this audience here, we saw wealth, the resource of our country, that is so rich that we don't have to go into a depression about any of the issues, because we were the ones who brought freedom into this country. You know, chairperson of the Commission for Gender Equality and also the Chapter 9s, I always say that in South Africa everything is possible. The good, the bad, and the ugly, and everything in between. But it's a land of possibilities. And the nice thing about our constitution is You see, somebody asked me about the conflict in India and Pakistan that you saw recently on TV. And they always got a blame game going back to 1948, where they said that, you know, the negotiated settlement between the partition of India and Pakistan happened in London. So blame the British, right? And they've got a point. We go to Zimbabwe, got the independence in 1980. Where was the constitution for Zimbabwe, for the freedom of Zimbabwe thrashed out? Lancaster House in London. But if you look at South Africa's constitution, where was it thrashed out? In South Africa. Who were the main actors? If you read a book called Tomorrow is Another Country by Alistair Sparks, you will understand what I'm saying. It was 26 different actors in this country that once upon a time couldn't see eye to eye across the table. But 26 different stakeholders with 26 different ideologies had the guts to say, you know what? Can we sit around the table and can we talk? And when they spoke and they shook hands, we saw the 27th of April 1994 with the most laudable constitution that people always talk to us about. So that in itself, colleagues, is a positive milestone, a step in the right direction to take us to where we want the country to go. So if something goes right, we should be all happy that we were part of the solution. And if something goes wrong, we must be brave enough to say, let's go back and let's revisit our analysis, do a situational analysis, and revisit where we come from, and let's leave a world for the better for future generations to come. So when Advocate Steenhuisen and I were having this discussion before this symposium, we reflected and we said, what should we do? Should we call a conference or should we call a symposium? And I reflected on it and I came back to it and I said, Advocate Steenhuisen, I think a symposium is more cozy, it's more intimate, and it will yield a better result. And I'm sure in this room and through the hybrid that we had with the audience from the external, we are now going in the right direction. Don't you agree with me, colleagues? And that is, this room is so rich in capacity that we heard from the global perspective, we heard from the judiciary, we heard from the legislature and the executive. And we said, you know what? The shoulder is here. The change agents are going to be here. And this is where we're going to go. When I saw those children, I made some copious notes. It reminded me of a time when I used to play barefoot at home in my neighborhood. I was a child. And I saw I saw the sparkle in the eyes of all our children here. And I said, but where did we go wrong? And so all of us have to go back home and reflect on how we want to see that society. Yes, we have the best constitution in the world. Everybody says that. Then we have the International Convention on the Rights of the Child with all its protocols. And that is in place itself. I ask myself, is there constitutional fatigue in this country to throw in the towel? Do we throw the towel in? And I say no. It reminds me of a joke, chairperson. I saw in the Sowetan, that time when there was a lot of child abuse in the country as well. So there was a caption by Zapiro in the Sowetan. and he saw these, he draws this bus that's going through the Kruger National Park, full of excitement of, people going to see what nature is all about, to connect with nature. And when the animals saw the human beings coming, all the animals ran into the forest with their children, and they said, we don't want to touch these people, because see what they do to their children. We don't want that to happen to our children. That's the abnormality. And we take things like this as a joke. And we think it's going to be somebody else's kind of challenge to make it happen. I'm not here to give a lecture. I think we spoke about these things. Elgin, I'm very grateful for the answer that you've given. Because when I heard that question, I thought it was an important question, because refugee law is becoming quite a big thing. So is xenophobia. And so is the undocumented children. Now, what was so beautiful about your answer, Elgin, and in my opening remarks, I made this statement, and I said the reason why pro bono is so good at what it does is because it knows where to find the right answers and the right help. So Elgin represents a law firm called, if I may, Elgin, Cliff Decker and Hoffmeyer. And they specialize in refugee law as one of their projects, not taking away from the other law firms as well. And we have 535 lawyers in our ecosystem that I mentioned that help pro bono to help the poor and the vulnerable find solutions. And hence I said that is why we need to call a symposium today. Because in that symposium you will find answers. I've invited deliberately, we took a deliberate decision to invite the chapter 9s, and they responded. And the reason why I asked them to come is because people don't understand the gravitas of these constitutional bodies. They have what we call the power of subpoena. And if you know the rule of law in this country, it says not even the president is above the law. So the chairperson of the CGE and the chairpersons of the chapter 9s have this power of subpoena to call the president, the number one in this country, to come and answer why things are not working when the Constitution gives rights and responsibilities. That's how powerful the chapter 9 is. So we are then saying, because of that, we need to go into a next level of relationship as pro bono. We've got the Legal Practice Act that is basically going to make 40 hours of pro bono compulsory for all 41,000 lawyers in this country. When that happens, obviously, you will find poor people getting the best legal help. So from 500 to 41,000, can you imagine the level of the service we're going to give to the most vulnerable and poor in our society? And so I'm saying is, in the same breath, we've got the chapter 9s. Now let me tell you about pro bono, where it's situated. It's at the women's jail on Constitutional Hill. And when people ask me, where do you work? Chairperson, I say to them, I work at the women's jail. So what do you do? No, I'm the National Director of Pro Bono. At the women's jail? Pro Bono? And so what is it that you do? I said, we help poor and vulnerable people. So I've got nothing to do with prisons, but it's just a historical museum there. But there's powerful actors there. And directly opposite Pro Bono is the Commission for Gender Equality. And I took it upon myself, and I went across and I introduced myself to the chairperson of the Commission for Gender Equality. And I said, we need to work closer with each other, because litigation is prohibitively very, very expensive. And not everybody can go to the Constitutional Court. But with you, I can go to the Constitutional Court, because I've got the best legal brains in the 535 lawyers. And one of them is Bowman, sitting there, who's doing an amicus application for us right into the Constitutional Court to support the case of the South African Human Rights Commission, whom the Supreme Court of Appeal said their powers are not binding. And I said, if that happens, it's the end of the road for the Chapter 9, which are constitutional bodies. So we asked Bowmans, help us to challenge this decision. And so we filed in the Constitutional Court as amicus in this matter, Chairperson. Because you have, and we asked the Commission for Gender Equality, please, you file as well. Because we are saying that these are powerful bodies that can resolve issues speedily, quicker, cheaper, and it's not cheap justice, it's effective justice that's meant to address the imbalances and the inequalities in society. Hence, we call this particular conference to say, we're renewing our vows here, and we are saying, let's go back to the drawing board, and let's go and see how we can make it better, and stronger and more effective. And that was the purpose of this conference. So people who have joined us on the hybrid as well, you know, we also want to thank them for their valuable time out here. And the point I'm making is if we join hands through a strategic collaboration partnership for impact, we are now sending strong signals to the state that we're not going to sit back and allow things to crumble. We are going to hold you accountable for the 27 rights that are entrenched in the Bill of Rights. So we're not asking for the moon, and we're not asking for the stars. We're asking for things that are rightfully due to us as South Africans that are living in this country. And we owe it to posterity to make sure that that will happen. So pro bono, I can assure you, has taken, you know, the lead into saying that we're going to challenge the system. We are poor, and we are donor-driven, but we have the gravitas to make a difference. Last year we did 5,037 cases. To date we've done 8,000 cases. And we put it on a digital case management platform. And we're revolutionizing this whole thing as well. And we're saying together we can make it happen. So on that note, I would want to say, I learned a lot from Kanteri, the choir. They basically said to us, please listen to us. Listen to our plight. Help us. We are the leaders of the future. And if you see the kind of depth in the few songs that they recited or they sang for us, you could see it came from the heart. And that's innocence. We cannot allow our children to be robbed of their innocence. That's the long and the short. We will not allow, we should take a firm commitment that we should not allow anybody's dignity to be impacted on. And we have the capacity and we have the know-how to protect that as our constitutional rights. So, Chairperson, I want to say to Ms. Abigail Noko, the head of the United Nations Human Rights Council for Southern Africa, to come and give us a wonderful overview of how we can make these rights realizable. We had Judge Linda Retief, who's an expert mediator, who basically shared her experiences on the bench and told us that we are on the right course. Ms. Daphne Naidu, what do we say? You're like part of the pro bono family, although you're from the state, but you know, you speak from the heart, you give us good advice, and we always improve the system according to that itself. So we want to say thank you to you and your team. And Chairperson of the CG, what do I say? I'm lost for words, but to say thank you to you and your wonderful team for believing in pro bono and for believing that together in the access to justice ecosystem, there are solutions, and we can make that happen. I would be failing in my duties if I did not say thank you to Pro Bono. Advocacy and Hazen, I gave you a very difficult task, and I did not interfere in how you carried out your work. I did not interfere in how you and Margaret engineered this whole conference together. But it was a learning experience and a learning curve for all of us. And the fact that we got the entire Pro Bono family here today shows that we are all serious about social justice issues in our country. I want to specifically say to our interns, you know, our interns come here, they work for Pro Bono for 1 year. They are there on their desk, chairperson, from Monday to Friday. I promise you, without fail, for 1 year they come there with just textbook knowledge from the universities with an LLB degree. But they start at 8 o'clock. Believe me, they start at 8 o'clock. We close at 4 o'clock. They go home at 5:30. I have to actually chase them home and remind them, you've got another life. But when they go out of the system after 1 year, and again I'm saying this to all the organized legal profession, if you're looking for serious candidate attorneys, at least shortlist them, and you will be not disappointed by taking any of them on board. They got a commitment to social justice, and we throw them right into the deep end, and they swim out of it beautifully. And when they come out of there, they see a world of law and social justice marrying each other for the benefit of the poor and vulnerable to live in dignity. So this is our team. We are 30 people. If I had more resources, I would expand into all 9 provinces, but I can't. I don't have the resources. So I have asked that today, chairperson of the Commission for Gender Equality and the other chapter 9s, for you to allow us to access justice for the poor and the vulnerable in all 9 provinces, because you have a carbon footprint in all 9 provinces. We can allow consultations to be taking place in places where people live through the facility that you can organize for us. We have 535 legal practitioners, and I'm sure if you give us that opportunity, chairperson, and we'll talk about it, we can get all the country lawyers as well in the other 9 provinces, outside the urban provinces, to give access to justice to poor people, free of charge, with dignity, and with solutions as well. So I'm going to appeal to us that at the next level of our friendship, chairperson, this is the next stage of our journey. And we will make access to justice realizable within the ecosystem for everybody. And what do I say now, Margaret? I say to everybody, you are invited, all of you are invited to a wonderful movie that's going to be shown tonight in the Avalon Cinema in Killarney Mall. It's called Greytown Girl. And Pro Bono does this from time to time, so we will invite you when that happens. So we have a strategic collaboration partnership with the Avalon Cinema group of companies. They are also social justice activists who always obliges to Pro Bono. And all I need to do is phone the CEO of the Avalon Cinema group of companies, Mr. A.B. Musa, and I say to him, please show this movie. And he is now obliged, and he's offered us to show this movie called The Greytown Girl. Why I'm saying this is important? Because it's about people who break the barriers of poverty to reach their dreams. And this is what this movie is about. This movie is a South African production that has gone to the Cannes Film Festival in France, and it's nominated as one of the movies that stepped to get an award for a South African production in that space. What does it mean? It means that it shows us something, that all those young actors that were part of this movie were youngsters who pursued their dreams in the arts, and they were given this opportunity. That is why I like to end off by saying South Africa is a land of possibilities. We just have to unleash the potential of our children, and they can go to global events, and they can raise the flag. Like Chairperson said, the Caster Semenya matter as well. It was through her office that we managed to get the presidency to fund that case for Caster Semenya, to fight for her dignity and her rights in the European Court of Human Rights as well. This is the power of Chapter 9s. So we have it all. The recipe is all there, Margaret. It's just how we want to bake the cake, whether you want to make it a cheesecake or a fruit cake. But it will be a cake that everybody can enjoy. This is what South Africa is all about. So on that note, Jabu says he's now absolved from his duties. Jabu, you've been excellent. We couldn't get anybody better when they said who must be the MC and the program director. I said, look, I'm going to ask if you can approach Jabu. And I didn't even approach the chairperson. That was wrong of me, because I know Jabu is a brilliant program director as well. So to all of you, in closing, I'm not going to repeat what everybody said, but it was a rich discussion, you must all admit. A lot of reflection. But what we're saying now, Chairperson, and this is important, is that Chapter 9s can hold the government accountable for its commitments it has made to the international body, to the Constitution and the Bill of Rights. And we'd ask you to help us to hold government responsible and accountable on what they've done in terms of service delivery to meet the obligations that they committed to on behalf of the Republic of South Africa to advance the rights and the protection of children. So I'm saying is, we are now on the 11th of June, 2025, 30 years later from the time we ratified this convention. But we can hold them accountable, Chairperson, to say that the National Development Plan Vision 2030 is not 100 years away. It's just 5 years away. And we can adopt a short-term strategy where we can call government of the day, especially the minister in the office of the presidency that deals with women, children, and people with disabilities, and ask them what is their plan of action to meet the access to justice goals of the National Development Plan in 2030. So they need to tell us what are they going to do in the short term, and we could say that, okay, if this is 2025, by 2026, give us a deliverable. In the medium term, 2027 to 2028, how far have you gone to meet those obligations? And 2028 to 2029 and 2030, how have you delivered? They can't complain about the resources because they need to budget for these things now and put a strong concrete plan of action. And in the same vein, the Sustainable Development Goals Vision 2030, 5 years away, South Africa has made international commitments there as well. Chairperson, there's work cut out for the CGE. There's work cut out for the Chapter 9s. And this is what we can do. And same goes with the African Union, Agenda 2063 as well, so that our children will see a better future than where we come from as well. And if you read the preamble of the Constitution, the first sentence, it says, we recognize the painful historical imbalances of the past. We undertake to make a better society. So on that note, thank you very much. It's been a very lively discussion, a beautiful symposium, and a lot to reflect on. So when you come the next time here, Elsaby, we're going to come and ask for concrete solutions on finding the roadmap towards a better life for all in this country. Thank you once again to everybody. God bless you. Have a wonderful trip back home. And for the others who will join us for the movie, it's free of charge. You just come and pick up your popcorn and your cold drink and enjoy this very thought-provoking movie. God bless and goodbye. Thank you.